Items for pronouncement of judgment. Item number 1, arbitration appeal 6 of 2010.
Appeal dismissed.
Item number 59, MSC appeal 300 of 2021.
Appeal partly allowed.
Item number 60, RSA 114 of 2024.
Second appeal dismissed. Yes, any mention?
Hello, Chief. I'd like to mention the distinctive matter for hearing in the daily court system.
When?
5th of December.
5th of December? Okay.
Earlier occasion it was fixed for hearing, but it's sent for mediation.
Okay.
For mediation failed.
Okay. Yes.
Milord, may I mention matter? Milord, I'm coming from Kolkata all the way. This matter is very urgent. There was an order on 31st August, Milord, to keep the matter up to 4 weeks. Now, Milord, 10 weeks have passed. This matter is not coming in the list.
When do you want?
Milord, as you lot is please, Milord.
Okay.
Maybe next week.
On 28th November.
We are grateful, Milord.
Excuse me. Lordship, may it please, as regards item number 12 of today's daily cause list, dear Lordship. Lordship, in this matter, I need to file one additional affidavit, dear Lordship. Let the matter come up in the coming week. In the meantime, we'll file an affidavit, dear Lordship.
Ms. B. Bhuya, learned senior counsel assisted by Ms.
B. Bora.
Learned counsel for the petitioner. Press for 1 week time so as to file an additional affidavit. Bear allowed.
May it please, my lord.
Ah.
May it please, my lord. I appear for the Cotton University, my lord. I'm the respondent in the instant case, my lord.
Yes.
My lord, my senior's name, Mr. P.D. Nair, may kindly be reflected in the cause list, my lord. It has not been reflected, my lord. SC Cotton University.
Next,
Mr. P.D.
on
Nair.
next date, we will consider it.
Lordship, may I pray for a fixed date because interim order is operating in this matter?
Kobe.
On 3rd December.
December.
3rd
Of
December.
December. Interim order
Oh,
will
yes,
continue.
yes,
my
no,
lord.
this-
All the
third-
interim order passed.
My lord, can it be on second?
2nd December.
Lies.
May it please, my lord. May it please, my lord. Prayer for listing of a IA, my lord. Tomorrow there is some urgency pertaining to the matter, my lord.
Tomorrow?
My lord.
Okay.
Deeply obliged.
Lordship, interim to continue, my lord.
Yes, continue.
Obliged.
Very pleasant. I am mentioning an IA, my lord, in MSc appeal for withdrawal of compensation.
When?
My lord, on 27, my 27 of this.
Of this month? Okay.
Okay.
May please, your lordship. I beg for listing of a CRT IO matter for tomorrow, your lordship. There is some urgency in this matter. My
Okay. Okay.
Your lordship, my lord, orders matter for release of 50%.
Okay.
Next Monday, 25th.
Next?
Next Monday, my lord.
May I please your lordship?
25th.
Ah.
Next Monday.
Yes, Mazumdar.
Lordship, I'd like to mention item number 5. Lordship,
Yes.
this matter may be adjourned for a week and may be listed after any date, Lordship,
After?
after a week.
After a week.
Lordship.
Mr. L.R. Mazumdar, learned counsel for the petitioner, submits that the matter may be listed after 1 week. Why?
My Lordship, some instruction is necessary and I have also not.
So as to enable him to obtain some instruction in this regard. Bear allowed.
All right.
My lord, may I pray for listing of this IA in the next week, my lord. I am for the respondent, my lord.
I for?
IA for substitution and all, my lord. I am for
Okay,
the respondent, my lord. Any date, my lord. Next week.
Yes, yes, madam.
May I please, your lordship? I beg to mention item number 58 for adjournment.
Why?
Lordship, my senior is out of station.
Who is your senior?
D. Bora.
Your good name, please?
K. Borman.
You inform the other side?
No, I'm for the petitioner.
No, you inform the other side?
Yeah, consent has been taken
From home?
from Dr. Sir.
Okay. Miss, your good name, please?
K. Borman.
Okay, Burman, learned counsel, appearing on behalf of Mr. D. Bora, learned counsel for the petitioner with consent from the other side, price for listening the matter when?
After 2 weeks,
After 2 weeks. Fair allowed.
deeply obliged.
May I please your lordship, my lord, I pray for listing of a writ petition, my lord, on any date, my lord, next week.
Okay,
My lord, another prayer, my lord, for listing of a contempt case, my lord. My lord, that may be listed as per the convenience of the court. Oblige, my lord.
May
Please, my lord. Lordship, I would like to mention for listing lordship MSc appeals to numbers of MSc appeals. Our condemnation delay it is not listed for admission from last 2 months, lordship.
On
Day after
20
day after tomorrow, lordship.
day of tomorrow.
possible.
On 21 on 21 on 22nd. One on 20th, another on 22nd.
For admission, lordship.
Pardon?
Admission, lordship.
Two
Pardon?
cases on a single.
For announcement admission after condemnation delay it is not listed, lordship.
Okay,
One
yes,
on
given the
20th,
date.
another on 22nd. There are two cases.
Hmm.
Yes, one on 20th, another on 22nd.
Yes,
I'm praying for listing of an IA lordship.
where?
Maybe tomorrow lordship. If there is an urgency, it's connected with MSc appeal lordship.
Okay, okay.
Hello, please.
May I please the lordship, I beg to mention for listing, bail appeal.
Bail application. Bail application,
Okay, another bench.
why you are mentioning this matter here?
So, last occasion was, directed for, LCR call within.
By this court,
Yes,
when do you want?
20.
20?
May it please your lordship, I beg to mention for listing of an IA lordship.
When?
Lordship, tomorrow. Lordship, actually, execution proceeding has been initiated in the trial court, lordship,
When
the executing
possible?
court.
On 22nd.
Lordship, the matter is fixed in the executing court on 21st, lordship.
Okay, okay. Yes,
May it please your lordship. Lordship, I beg to mention for listing of a CRP, my lord. For
Where?
admission any date, my lord.
okay.
December, in the month of December.
Any date may be.
4th December.
Oblige, lord.
Yes.
My lord, the petitioners were working as CRCCs, my lord, cluster resource center workers. And suddenly, my lord, there was some problem with the service conditions. And they approached the authorities. Authorities, my lord, instead of resolving, they've directly sent them back to the remote parent school, my lord. Transfer matter, very urgent, my lord. Can I move it tomorrow, my lord?
No, what wrong with that order?
Because, my lord, the authority where we placed the representation, they resolved the issue. The district mission coordinator resolved the issue. And subsequently, my lord, the mission director, he issued the impugn order. He has absolutely no role to play in the entire chain of events, my lord. I'll satisfy your lordship, my lord. Can it be tomorrow, my lord? Extremely urgent.
Tomorrow already we have given. four
Fresh
cases.
motion, my lord.
Already we have given 4 cases for tomorrow.
Fresh motion.
On
Day
20th,
after,
Wednesday,
day after
day after
tomorrow?
tomorrow. 20.
Yes,
May I please, lordship, lordship, with concern from the other side, I beg to mention item number 21, lordship. Angus counsel is not present due to some medical difficulties. Lordship, may.
item number 21.
21, lordship. Lordship, may I fix the matter.
Your good name, please?
M. Alam.
Mr. M. Alam, learned counsel for the petitioner with consent from the other side, press for listing the matter. When?
After 2 weeks.
After 2 weeks. Where, Lord?
Deeply
Is there any interim order?
No, lordship.
Lordship, in the item 21. So in the causes, the higher education is shown, lordship. Actually, matter relates to elementary education, lordship.
Hmm.
Item 21, lordship.
Your good name, please?
As Bhuya.
Mr. S. Bhuya, learned counsel appearing on behalf of
I'm sitting on higher education, lordship.
learned standing counsel for higher education department submits that actually this matter relates to elementary education department as such. It is contended that the name of the standing counsel of the elementary education department has to be shown in the cause list. Rest shall do the needful in this regard.
May it please the lordship, I beg to mention an MSc appeal for hearing, my lord.
When?
My lord, any date on the next week, my lord, will be convenient. If the
Next week,
For hearing.
For hearing, my lord, because the urgency in this case is, my lord, it was last extended in 2024 May, my lord. But the claimant number 1, the mother is unwell, my lord. She might expire in, it is the only. If my lord can place it any day.
MSc appeal, MSc appeal.
when?
MSc appeal, 28 Thursday.
My lord, please.
May I please, my lord. My lord, listing for a interlocutory application, my lord, maybe 28 or 29th of this month.
29th.
Yes.
This matter relates to admission in PG courses in Guwahati Medical Colleges, my lord.
is already my notification for counseling has been issued, my lord.
Hmm.
So from today, registration has started, my lord. So it's most urgent, my lord. It may be taken up tomorrow, my lord. Very urgent, my lord. Deeply obliged, my lord.
May please to look, I would mention for to MSc attend. Yes.
When?
Next week, Lord. Any day.
Okay.
On 28.
Lordship, in item 61, we have appeared for the petition, and Lordship. Herein, we have filed an affidavit in reply to the affidavit in opposition filed by the respondent number 2, Lordship. Lordship may call.
Item number 61.
Yes, Lordship. Lordship may
61, it is in the motion column.
Yes, Lordship. Lordship may call for that affidavit in reply, Lordship.
Okay. Okay.
And in one more prayer, Lordship. In item 40, I appear for the respondent number 6 and 7. Lordship, we need to file our affidavit in opposition in that case.
Item number 40.
Yes, Lordship. Lordship may kindly grant us some time.
Can it be fixed when I am the petitioner in this case?
You are for?
I am for respondent number 6 and 7.
Respondent number 6 and 7. You are Mr. Chakraborty,
No, I am MP Sharma, Lordship.
MP?
Sharma.
MP Sharma. Mr. MP Sharma, learned counsel for the respondent number 6 and 7. With consent from the other side, press for listing the matter after?
So 2 weeks, Lordship, at least.
After?
2 weeks.
2 weeks.
Can it be fixed, my lord?
Okay, go ahead.
On 9th December.
They are allowed. Rest is list the matter on 9th of December.
Obliged. May it please, Lordships. I beg to mention item number 14, motion, my lord. Can it be taken up next week, my lord? I have personal difficulties. 14.
Your good name, please.
R. Islam.
Mr. R. Islam, learned counsel for the petitioner. Press for listing the matter in the next week.
Next.
Fair lot.
Deeply obliged. So items for motion, item number 2. Please, Your Lordship. Order of this honorable court, pasted. Direction by Lordship, para number 4.
Yes.
Where in view of the above, we required a petitioner to prepare an appeal under section 14 of the 2017 law before the Secretary, Department of School Education, Assam, raising hearing his aim for being considered for police organization against an additional post. And my lordship petitioner filed an appeal is 14. 18/12/2023, petitioner filed an appeal. But no action was taken. In moments.
Yes, Secretary Education Department. Secondary Education. Mr. Khatoni, you have received the notice? Yeah.
No, my lord.
No.
It's a contempt, my lord. It's a contempt, my lord.
Contempt.
Yes, my lord. Notice will do, my lord.
Okay. Heard, Mr.
And
Learned counsel for the petitioner. In this petition under section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, is preferred by the petitioner Kamaluddin Ahmed for willful and deliberate violation of the order dated 5/12/2023 passed by this court in WPC number 493 of 2023. Where is the petition? And the order dated 5/12/2023 passed in WPC number 493 of 2023. Let notice be issued to the respondent returnable in 4 weeks. Since Mr. Khatoni, learned Standing counsel for the secondary education department entered appearance. No formal notice is required to be issued. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks. So as to enable Mr. Katunier to obtain necessary instruction in this regard. List after 4 weeks.
Yes. So item number 3. Minus 3. Minus order of this honorable court is pending.
Here also same,
Same.
respondent same,
Respondent secretary.
same order, Mr. Katunier?
Yes, yes, madam.
Same order.
Item number 4. Please, Your Lordship. Well, there is a willful and deliberate violation of the order dated 19/2/2024, my lord. First in WPC 4181/21, my lord. Page, my lord, 14. Operating part is page, my lord, page 17, my lord. The entire exercise be completed after receipt of individual evaluation within a period of 30 days from the date of filing of this application, my lord. Petitioner filed application, my lord, on 28/2/2024, my lord. But thereafter, no, my lord, order has been, reason order has been passed, my lord. And he time to time file application and also remind personally, my lord.
Secondary education?
My lord, in this petition, my lord, the principal secretary finance, my lord, was respondent number 2. But the post is lying vacant. Accordingly, my lord, I have filed an IA to implement the, my lord, commissioner and secretary finance department, my lord. And also order was some hide application dated, my lord, application dated, my lord, 10/9/2024, my lord. Well, it implementation may be allowed.
Heard, Mr.
M. Islam.
M. Islam, learned counsel for the petitioner. In this petition under section 11 and 12 of the Contempt of Court Act 1971, Radio 34-215 of the Constitution of India. Instituted by the petitioner Mohammad Shaukat Ali for willful and deliberate disobedience and violation of the judgment and order dated 19/2/2024, passed by this court in WPC number 4181 of 2021. Where is the petition and the order dated 19/2/2024? Let notice be issued to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process to the respondent number 3 and 4. And Mr. Katunier, are you representing at the Government of Assam Department of School Education? However, no formal notice is required to be issued to respondent number 1 and 2. To contempt number 1 and 2, since Mr. Katunier, learned standing counsel, appears and receives notice on their behalf. This is the matter after 4 weeks.
IS secretary and director.
I allow.
My lord. Item 6. Implemented, my lord, the amendment cost title may be allowed to.
Amended cost title shall be furnished within a period of 1 week from today.
My lord. Highly obliged, your lords. Item 6.
My matter may be taken up with sometime also. My senior is letting me work.
Who is your senior?
LR Motunda.
Item 7.
Lordship, time being lordship, HR of the time being lordship.
Item 8.
For timing, my senior another one.
9.
Item 9.
That is a lot. The petitioner is a Arabic teacher in the high school under Barbata district, my lord. You see, her service was not provincialized under 2011 Act. After the district scrutiny committee is recommended her name as eligible. Thereafter, after 17 years, her name is recommended, but her service was not provincialized. This was not provincialized, her name was not included in the UDAS code, my lord. The petitioner is a teacher of high school, so the UDAS code, non-inclusion of the name of the petitioner in UDAS code is not necessary, my lord. This is only for elementary education, that is, which is clearly described in section 2(1) of this new act, my lord. And the petitioner, a list of provincial job teachers who are eligible for provincialization of service was prepared by the commissioner and secretary, where the 414 teacher where name was listed, where the petitioner name was reflected in serial number 22, that is annexure 6, page 21, 29A, but type copy I have annex a type copy, that is 29, my lord. That is very eligible. Ranuma Ahmed, my lord. As her name was not inclusion in the DIAS code, that is why after eligible, her service was not provincialized. And similarly situated persons whose service was not provincialized due to non-inclusion of the name of the UDAS code, they approached before this court, my lord, and that is annexure 8, page 46. After hearing of the matter, this court has disposed of the matter to, I am reading, page 53. It is provided that last part, page 50, that the state level scrutiny committee has any apprehension with regard to the continuous nature of service of the petitioners. The state committee is required to invoke the powers as conferred on it under the provision of section 1311 of the 2017 Act. The state committee, in terms of the provision of the section 1311 of the 2017 Act, shall cause physical verification of the institutions of the petitioner and also inspect of all document and record as may be required for the purpose of consideration of the cases of the petitioner for provincialization of their service, and thereafter render its recommendation in the matter. On receipt of such recommendations as from the state level scrutiny committee, the Director of Secondary Education Assam shall proceed with the matter and takes its program to its logical conclusion. The process is required to be now carried out by the Director of Secondary Education Assam shall be so initiated and completed in terms of the direction passed herein above within a period of 3 months from the date of receipt. After that, this petitioner, as already verification is conducted by the state level committee. As the petition, if that matter may be present, petitioner case may be disposed of with the direction of this court, and thereafter the petitioner is maybe verification by the state level committee, and his name has already been stating as eligible, and thereby her name was reflected in serial number 22. My prayer is before this court that as he was already eligible by the district scrutiny committee and her name is reflected in the list prepared by the commissioner and secretary, so the matter may be disposed of with a direction to consider in the light of the decision made by this court.
Yes, Mr. Khatonia.
Well, kindly come to page 45, my lord, which is impugn in this petition, my lord. Page 45. This is a letter written by the Director of Secondary Education to the all inspector of schools. May I read, my lord? With reference to the subject cited above, I would like to inform you that the government letter mentioned above under reference requested this director to furnish report regarding non-inclusion of the names of teachers, tutors in UDIS data, and for the reason of which they were left out from provincialization of their services in the school. In this connection, you are therefore requested to furnish the relevant data of incumbents under your jurisdiction as per the format attached within 2 days. But in fact, the director has sought information from the inspector of schools why they have not their service have not been provincialized, my lord.
Mm.
So, on the other hand, my lord, by my learned friend, this letter is impugned in this writ petition, my lord.
Mm.
Yes,
So,
yes.
at this
No,
stage, my
no,
lord,
my
I'm
lord.
not sure, my lord, why she has made this letter is impugned. Because from why this letter, my lord, information was sought from the inspector of schools, why they have been left out. So, my lord, may this is issue notice, my lord. I'll obtain the instruction, my lord.
Lordships, as the petitioner, already the inspector had submitted the reason why her name was not included in UDAS data.
Mm.
That after 2013, the petitioner service was not provincialization. This is a computer systematic generated. Those services who are provincialized, their name is included in the UDAS data. As the petitioner service was not provincialized by the respondent authority after duly recommended by the district scrutiny committee, because of that, her name was not included, the computer will not accept it as her services are not provincialized. But thereafter, when the 2017 Act came into force, when the petitioner submitted all the relevant documents, and the district scrutiny committee has again recommended her that she is eligible as a third teacher, as there is a government notification that I have annexed where it is clearly stated.
Mm.
I have annexed the government notification, my lord.
Mr. Katonier, if the present petitioner is similarly situated with the petitioners in WPC number 310
Yes, my
of
lord.
2024, why we cannot grant similar relief to her?
Because I'm not sure from the pleadings, it is not sure that whether this petitioner is similarly situated or not, my lord. Because my landlord frame is submitting that the district scrutiny committee has recommended her name, but
Mm.
that recommendation is not annexed with the writ petition, my lord.
But this is the list of 414 which was prepared by the commissioner and secretary, where there is clearly stated the name of the drop teacher found eligible for provincialized of service of teachers and tutors. That is
At
prepared
page
at-
number,
on the
Page number 29, my lord.
29A, my lord, but petitioner name was reflected in serial number 22, my lord. All the other petitioners
Mm.
were approached before this court with that petition, they were also included in the name. Their name was not included in the UDAS data. So the same thing, my lord, that if the petitioner was not relieved from this court, then no physical verification will be done by the state level committee.
Mm.
And in a very near future, the government is going to provincialize a batch of writ petitioner from this list, my lord. Again, the petitioner was left out due to non-inclusion of the UDAS data. The UDAS data is not a compulsory in the high school level, my lord. This is only for elementary student, elementary school. So the petitioner is working as a high school. And lordship, kindly come to the page 27, where the director issued a letter to the secretary. The provincialized of service of third Arabic teacher of 5 class high school, where the petitioner name reflected in serial number 3. Islamic Jyoti BDK High School, Ranuma Ahmed. So, my lord, if it is notice will go and another 4 weeks, 5 weeks, 10 weeks, we get to reply. And again, she was left out when the list is going to be, the batch of petitioner were going to be provincialized by the government. Then
Mr. Katonier, we'll take it up at 2 o'clock. In the meantime, you please go through the.
I have gone through the documents, my lord.
Yes.
But thing is that, my lord, whether her case was not considered on because of UDAS, that is also not reflected in the writ petition, my lord. Any documents.
UDAS code is not necessary in the high school level.
That is why I'm saying. That is why I'm saying why her case was not considered. That is not reasonable from the repetition, readings of the repetition. So my lord may issue short notice so that I can obtain instruction from the department. And my lord may dispose if it is covered by the.
Come on, next week, my lord.
Next week, okay.
Next week, and he will take the. And item number 11 is also same. Only district is defined. That is Kachar district.
Your good name, madam?
A. Bujar Borwa.
Mrs. A. Bujar Borwa. Learned counsel for the petitioner and Mr. Khatunier for the respondents. Oh, all the respondents?
Yes.
Yes, ma'am.
Mr. Khatunier?
Except respondent number 5.
Except
5
Mr.
and 3. 5 and 3, ma'am.
Let it be counted.
Respondent number 1, 2, and 4, and Madam Burman for the respondent number 5 and
Only three, ma'am.
3, only 3. The grievance of the petitioner sought to be addressed in this petition is that she was appointed by the school managing committee
As Arabic teacher, madam.
as Arabic teacher in which school?
In Islam, Islam Jyoti, Islam Jyoti,
BDK High Madrasa.
High Madrasa School.
Islam Jyoti BDK High Madrasa School
Under Barpeta district.
under Barpeta district.
What did you look at it? What did you do?
The school was provincialized under Assam Venture Educational Institution Provincialization of Service Act 2011 as amended in the year 2012 with effect from 1/1/2013. But the service of the petitioner was not provincialized. Even after duly verified and found in conformity with the Provincialization Act 2011. Thereafter, the earlier Act of 2011 was replaced by the Education Department, by the Education Department as the Assam Education Provincialization Services of Teachers and Reorganization of Educational Institution Act 2017. Thereafter, the headmaster of the school of the petitioner applied for provincialization by submitting all the relevant documents before the district level scrutiny committee, Barpeta, but her service was not provincialized even after sufficient enrollment of the school in the petitioner's school. And thereafter, the district level scrutiny committee, Barpeta, has recommended the name of the petitioner as eligible for provincialization, and the same was forwarded to the Director of Secondary Education Assam. But again, she was left out from being provincialized on the ground that her name was not reflected in the EU Dias Code. It is the contention of the petitioner that Dias Code is not a requirement for provincialization of services in high school under Section 3, which is 1 of the said Provincialization Act 2017. Let notice be issued to the respondents, returnable in 4 weeks. Whether notice is required to be issued to respondent number 5, headmaster?
Whether number 5 has forwarded the name of the petitioner is not. Whether he has forwarded his her name or not, my lord, that can be ascertained from the number 5.
Yes, madam, then issue notice to the respondent number
Let them
5.
take instruction from the office of the director, and the matter may be heard on 28th or 25th of this month. If not, the court is not satisfied, then the notice may issue. That will be better, Mike. Otherwise, it will be delayed for another 2-3 months, and thereafter petitioner again later.
Let notice be issued to the respondents, returnable on when?
25th or 26th.
But on here?
Yes, my lord.
25th. However, no formal notice is required to be issued to the respondent number 1, 2, 3, and 4, since Mr. Khatonier, Learned Standing Council, appears for respondent number 1, 2, and 4, and Ms. Barman for respondent number 3. Mr. Khatonier, Learned Standing Council for the respondent number 1, 2, and 4 shall obtain necessary instruction in this regard and place the same before this court on 25th. Till then,
On 28th, madam.
28. Issuance of notice to the respondent number 5 will be considered on that list on 28. Item number 11 is same.
Same, Kali, only district is different, my lord.
Okay. Same. Okay.
Not so.
Okay.
Pending item 7.
Okay, my lord, I was another court man.
No problem.
Your lordship kindly see the order dated by the 8/11/24. And thereafter another order. This is a case regarding appointment of an assistant professor in English department, madam. Initially, advertisement was done in terms of the office memorandum. Subsequently, they have modified. So instruction was, madam, the director to be given with instruction, madam, whether they are going to implement this one or the earlier memorandum, madam.
The second memorandum, which my senior was pointing out, Lordship. Here, it is said that it is the modification of the earlier. It's not a entirely new Lordship memorandum, Lordship. It's partial modification. So both the Lordship, the initial one as well as this one will, the new one will incorporate in the initial one. This is the instruction, Lordship, I have received.
Let them put an affidavit, my lord. Immediately, madam. Your lordship kindly say, madam, first you kindly have a look to my advertisement, madam. Page 21. Page 21. Page 21, right side, my lord, your lordship will find Mandi Anthony College. Your lordship got it, madam?
Got it.
Yes, madam. Your lordship will find terms and conditions. Number 2, madam, this is English, one post for English and librarian. Terms and conditions, your lordship will find the educational qualification and selection procedures will be as per government office memorandum number so and so dated 24/1/22. Now your lordship of 21/22 is page, your lordship will find 22 one. Oh, so page 17, page 17. I take to your lordship to direct to page 19, madam. Page 19. Lordship will find marking of academic records will be calculated as mentioned below. My case follows as serial number 4, madam. Graduate. Your lordship will find 90% and above. My total marks is 72% marks academic marks, madam. Calculation is made as per this roster, madam. Now, so far the marking calculation, 90% and above, my lord, 30 marks is allotted for that, my lord. Then 80% to less than 90%, 27 marks. 65 to less than 80, 22 marks. Thereafter, my lord, that I am not on that, I am only first one, my lord. So this is, now this has been changed by subsequent page 22, your worship. Page 22. My learned friend is saying that, my lord, it is a modification. It is true, but you have modified, you have changed that one, my lord. The partial modification of the guidelines, it is dated, date, your lord's kindly say, date is 22/10/24. After the advertisement, after the last date, the process started, but after the last date, this was changed. Only to accommodate someone, my lord. Change means your lordship will have partial modification. Office memorandum dated 24th January, just your lordship has seen. Issued by Higher Education, the Government of Assam in the Higher Education Department is pleased to notify the following revision in guidelines for selection of assistant professor of the Rabindra Government College and so on and so on. Revision of calculation of marks of post-graduation. Only that part they have modified. That is ideal, it was 90%. Now they say more than 80, he will get 30%, 30 marks. Your lordship got my
Yes.
point, my lord.
No,
So
once
the,
the process is a begin,
yes, already.
you
they
cannot change the terms and conditions.
Lordship, we have not changed the eligibility criteria or something like that, Lordship.
Hmm.
This is the partial modification on the allotting of marks.
That is also, my lord. This is the- Oh, sorry.
One by one.
Yeah. This is only, Lordship, partial allotment of marks, and till now, Lordship, the selection process has not started. And moreover, Lordship, even that also this case is premature case in terms of the Lordship or rule of 2010 rule of higher education department. Lordship, as per rule, Lordship, the after the governing body or the selection body, after selecting a candidate, then they will have to forward the case to the director, and director is the authority to give the Lordship whether it is correct or not, the process of selection is correct or not. So till now, Lordship, the process has not started, Lordship, and this is the partial modification which the instruction says. Lordship, I have this.
No, when the process starts,
No,
after publication of the advertisement,
But Lordship, the marking system or the interview, etc., has not started. And eligibility criteria, the basic thing, eligibility criteria has not been changed till then. Lordship, we will file affidavit in that regard.
okay,
But
let
the-
them file affidavit then.
In the meantime, they should not proceed, madam, because already started, madam. Like, we applied.
But it's a-
What they are doing, madam, marks, allotment of marks, they are changing, madam. Only because to accommodate someone else, madam.
Lordship,
They came to know that, my lord, I am going to be appointed because of my merit, madam.
otherwise,
All throughout, madam, my merit is very good, madam.
Lordship may, go through the Lordship, I would like to read the rule 7 of the Lordship or Assam College Employees Provincial Education Rules 2004. Rule 7 clearly says, Lordship, that all appointment either by direct recruitment or by a promotion shall be made by director on the basis of recommendations of the governing body based on the recommendations of the selection committee. Here, Lordship, selection committee has not started interview, not given anything, not given marks, and they have yet to forward it to the director. Director is not a rubber stamp, Lordship. You will have to look into the process they have adopted or not. So, Lordship, it's a premature case.
No. The question is, are you entitled to change the terms and conditions?
Terms and
Once
conditions-
the advertisement is
if-
published and the candidates have applied for,
It's a Lordship partial modification, and not only for this, only the post graduation, Lordship. We have changed it for all the graduation, 55 marks, 55% marks will now get 27. Earlier it was given 34, 24 marks. Lordship, let me go to the instruction, Lordship. It's clearly stated there. Last paragraph, that vote will prevail, Lordship. At paragraph 9 of the instruction, it says, Lordship, moreover, in this particular case, the advertisement for selection for this post of assistant professor and librarian was published on 2/7/2024, but till date, the selection process has not started. Hence, the OM dated 22/10/2024, along with the
no,
order.
that is your contention, but you tell me when the process starts after publication of the advertisement,
Lordship, we will file affidavit.
you will file affidavit.
But in the meantime, they should not proceed, madam. If they proceed on this line, my lord, certainly I will be prejudiced, my lord. Your lordship process started the advertisement, your lordship very much aware, my lord. After having vast experience in the service, my lord, your lordship, the advertisement started the advertisement. We applied, all other candidates applied. Now when they came to know that somebody of their choice, my lord, may not get admission, my lord, they put it, they change it, my lord. Only that part, postgraduate mark. If they say, my lord, they will apply that official one which was.
Okay. Heard, Mr. Soduri, learned senior counsel assisted by Mr. Learned counsel for the petitioner and Mr. A.R. Towilder.
Lordship,
Learned counsel, standing counsel for the
phone number 1,
respondent number 1,
1 and 3.
1 and 3.
Lordship.
Who is for rest of the respondents?
Hmm? 1, 2, my lord. 1, 2, 2 minutes. Huh? UGC.
Who is UGC?
1 and 3, my learned friend, my lord. 4 and 5, 4, 5 and 6, my lord, private. Governing body, they may take, my lord. No. Both those 3 as well as your lordship has registered for.
Person to order dated 8/11/2024, Mr. Towilder, learned standing counsel for the department has obtained necessary instruction and placed the same before this court. At this instance, Mr. Acer Sodhur, Ladakh Chino Council submits that the concerned department may be directed to file an affidavit in view of the instruction received by learned standing counsel for the department. Accordingly, it is provided that Mr. Tobelder, learned standing counsel for the higher education department shall furnish and shall file an affidavit incorporating the instruction received by him. Mr. Acer Sodhur, learned senior counsel submits that if selection process is started on the basis of the subsequent notification dated
dated 22/10/24, page 22.
22/10/2024, then serious prejudice will be caused to the petitioner. And therefore, Mr. Sodhuri contended that till filing of the affidavit, the process may be stayed. But having considered the submission of Mr. Sodhuri, learned counsel for the petitioner, this court is
15,
inclined to stay.
page 15, my interim plan. Page 15.
The process till returnable date, till next date. Please the matter on, we'll fix that date then. When? Short date,
On 9th December,
9th.
9 December,
9 December. Can it be prior to that?
on 4th December.
Yes.
Item number 10.
Mainly by the appointing authority, that my respond number 4, 5, and 6.
Yes.
They have issued the office memorandum, and they are to act upon my lord, respondent number 4, 5, and 6. So they should not proceed with this subsequent memorandum. That is my fair.
Yes.
My obliged to.
That is a part of the, this is not a new memorandum, that partial vote may be. not-
That's my lord.
Okay, partial.
Obliged to.
Item 10.
Lordship, joint senior counsel Mr. K. N. Chaudhary is on lag, Lordship. So kindly take up after some time, also time.
Okay.
Obliged, Lordship.
Item 13.
Lordship,
matter is pertaining to compensation of appointment, Lordship. Lordship, I am challenging one office memorandum, Lordship. Annexure 8, Lordship, page 51, Lordship. Whereby Government of Assam has taken a decision to not to place any, Lordship, proposal before the SLC or DLC, Lordship. Lordship, one similar matter is pending, Lordship.
Are you getting pension for this
No, Lordship.
compassionate family pension scheme?
No, Lordship,
Under.
compensation or appointment, Lordship.
No. This because of the subsequent schemes, are you getting pension?
No, Lordship, my husband died in the year 2016, Lordship.
Is fell under the old pension scheme, my lord.
Old pension
Old
scheme.
pension scheme, my lord. After 2005, my lord, and in the service, they will entitle for a new pension scheme, my lord.
Was duly recommended me, Lordship. Thereafter, my proposal was forwarded to SLC. But Lordship, on 18/9, Lordship, one office memorandum has been issued whereby government has taken a decision to not to place any matter before the SLC or DLC, Lordship. Due to the improvement, Lordship, OM, Lordship, my right has been curtailed, Lordship.
When the matter is listed, this matter,
Lordship, in this method, there is no fixed, Lordship, only notice was issued and
so we'll take this matter along with that matter.
yes, Lordship.
Okay. Heard, Mr.
Jayati
Learned counsel for the petitioner, and Mr. P. Soikia, learned standing counsel for the respondent number
I have my lord 1, 3, and 6.
1, 3, and 6, and Mr.
Hi, Kolita. My lord, I am for the respondent number 5.
Pai Kolita, learned standing counsel for the respondent number 5, and Khatania for respondent number 2 and 4. In this petition, under Article 226 of the Constitution of India, the petitioner has put to challenge the validity of the impugned notification dated
18 September, page 51, my lord.
18/9/2024, issued by the Commissioner and Secretary to the Gokta Assam Personnel B Department, Dishpur. The grievance of the petitioner is that her husband, late Priyanath Gogoi, was serving as an assistant teacher of Nagajan LP School, and he died in harness on 22/1/2016 during his service tenure. Thereafter, the petitioner has applied for appointment on compassionate ground. And the proposal of the petitioner for being appointed as compassionate ground was recommended for grade 4 post under PAC Department, Sibsagar Division, by the district level committee Sibsagar in its meeting held on 11/8/2023. Thereafter, the proposal was duly forwarded to the Deputy Secretary to the Gokta Assam Department of School Education, Guwahati, for placing the same before the state level committee for further consideration as per norms. But before a decision is taken by state level committee on the proposal of the petitioner, the Commissioner and Secretary to the Gokta Assam Personnel B Department issued impugned notification, impugned OM, dated 18/9/2024, deciding that no case for appointment on compassionate grounds shall be entertained by any administrative department, stroke authority for any reason whatsoever, nor be placed before the state level committee, stroke district level committee for recommendation of the candidate for appointment on compassionate ground. And as such, the state level committee has refused to consider the proposal of the petitioner. Therefore, the petitioner has challenged the OM dated 18/9/2024. The learned counsel for the petitioner submits that in connection with same matter, another writ petition being WPC number 5067 of 2024 is pending before this court. And by order dated 30/9/2024, the the respondents in the personnel B department of the state was directed to clarify its stand relating to OM dated 18/9/2024. And as such, this matter, this writ petition may be taken to the writ petition number 5067 of 2024. Where is accordingly allowed list the matter on. Should we fix a date?
My lord, may I pray, my lord? Notice has issued, my lord.
Yeah.
My lord, other pending matter is in the same use of my lord.
there a depth of repetition? My lord?
No, in the early, no, in the, okay, issue notice, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process upon respondent number.
But we all are represented, my lord. 1, 3, and 4, 6, my lord, I'm representing. No,
Returnable in for 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged by their standing counsel. However, extra requisite copy of the petition be furnished to the learned standing counsel during the course of the day. This is the matter along with WPC number 5067 of 2024. After 4 weeks,
my lord.
Item 15.
Yes, sir.
Pursuant to a valid selection process, the petitioner was appointed as an LDA in Bamundi High School, my lord. Page 28, my lord. Page 28. This is my appointment letter. Dated 19 March 1999, subject to discharge without notice and without assigning any reason thereof, Sri Subodh Kolita, a selected candidate selected by the selection board, is hereby appointed to act as an LDA at Bamundi High School in the scale of pay of so and so, with effect from the date of joining. And he joined, my lord. Thereafter, my lord, he was upgraded to the post of assistant teacher in 8/3/2001, my lord, which your lordship will find at page 30. Page 30, my lord. Your lordship will see he was on 8th March 2001, he was upgraded, my lord. Subsequently, my lord, one Sondan Kolita filed a writ petition. It was registered and numbered as 1766 of 1999. And the order starts at page 32, my lord. Page 32. It is an order dated 5/4/2001. And the relevant portion your lordship will find at page 33, my lord. Page 33, the last paragraph. Page 33, my lord. Second paragraph. Keeping in view of all these existing facts and circumstances of the case and the established principles of law that selected candidate or selectee, though he or she cannot claim for the appointment to particular post or post on the basis of the selection or on the ground that he or she selectee has a legal right for considering of such appointment to the authority concerned, are bound to give reasons. Keeping these principles of law, I direct the official respondents, particularly the respondent number 2 and 3, to examine and consider the case of the petitioner on the basis of available materials on record. And also keeping in view of the factum of the service of respondent number 5 as an assistant teacher at the moment, not as a LDA as per the related order dated 8/3/2001. So, my lord, the petition of Sondan Kolita was disposed of by directing the authorities to consider his representation. Thereafter, my lord, the order of my upgradation was withdrawn, by which I was upgraded as an assistant teacher. And I had to come before this honorable court, which your lordship will find at page 45, my lord. Page 45. I came before this honorable court, and page 46, your lordship will see this honorable court issued notice. After I filed the writ petition, my lord, the authorities withdrew the order of my lord withdrawal, which your lordship will find at page 49. Page 49, my lord. There's an order dated 1st July 2005. In pursuance of the Honorable Guwahati High Court's order dated so-and-so in WPC number so-and-so, this office order issued under memo dated 24/2001 is hereby withdrawn with immediate effect. Thereafter, my lord, that Sri Sondan Kolita filed another writ petition for consideration of his representation, which your lordship will find at page 51, my lord. Page 51, and the relevant portion your lordship will find in the next page, page 52. And the same thing, my lord, materials on record. I am, as agreed by the learned counsel for the parties appearing before me, inclined to dispose of this petition at this stage with the following directions. The respondent number 1, namely Commissioner and Secretary, shall examine and consider the petitioner's representation in accordance with law and in terms of the relevant policy guidelines, if any, issued by the authorities. And this is how the second petition was also disposed of. In 2012, my lord, my services were confirmed, which your lordship will find at page 54, my lord. Page 54. Your lordship will kindly see, my lord, page 54, there's an order dated 28/9/2012. the service of Sri Subodh Kolita, assistant teacher of Bamundi, is hereby confirmed against the post created number so and so and written by government order number so and so. My services were confirmed. Now, another petition was filed by that Sandan Kolita. He was also a candidate in the earlier selection process, and that your lordship will see at page 56, my lord. Page 56. And the relevant portion your lordship will find at page 66. It starts at page 56, my lord, and the relevant portion, my lord, will find at page 66. Paragraph 38. Page 66, my lord. After the compliance of the order dated 2/1/2006 passed in WBC number so and so by the respondent number 1, as directed above, the respondents in secondary education department shall take appropriate steps in accordance with law as to whether it should proceed with the process of filling up of the post of LDA in Bamundi in terms of advertisement dated 11/12 issued by the inspector. However, till the said decision of the respondent number 1, that is commissioner and secretary, as directed above, the respondents in secondary education department shall not take any steps to proceed with the process of recruitment of the post of LDA in terms of the said advertisement. And secondly, my lord, in the next paragraph, regarding the post of assistant teacher in Bamundi that fell vacant on upgradation of Sri Ranjan Kolita, the respondents in education department shall do the needful in accordance with law, my lord, after considering the final orders passed by WBC number so and so and so and so that were preferred by the respondent number 5. Now, subsequent thereto, my lord, an office order was issued on 26/6/2023, which your lordship will find at page 68, my lord. Page 68. Page 68 and 73 is the operative portion, my lord. Page 73 is the operative portion. It says, page 73, my lord, after careful consideration of the above fact and circumstances and after examination of records, papers, including the representation of the petitioner dated so and so, it is found that the appointment of Sri Subodh Kolita does not appear to be just and proper, as he was appointed on the basis of such selection list. There was no signature of the chairman, member, etc. of the selection committee. So they say that my appointment was not just and proper. Thereafter, after the passing of this order, my lord, another order was passed by the department, which your lordship will find at page 78, my lord. Not 78, my lord, page number 80, my lord. Page number 80, there is an order dated 19 February 2024, page number 80. And they say in that order, in continuation to this department's earlier order number so and so, dated so and so, issued in compliance of the Honorable High Court's order passed in so and so and so and so, the government in the Department of School Education has decided to terminate the services of Sri Subodh Kolita, who was appointed as the LDA in Bamundi and thereafter upgraded as assistant teacher in the same school with immediate effect. Accordingly, the appointing authority is hereby directed to take immediate necessary follow-up steps for termination. And thereafter, my lord, if your lordship kindly turns to page 82, this is where the impugn order lies. 5th March 2024, they say, as per order number so and so dated 19 February 2024, the service of Subodh Kolita is posted hereby as assistant teacher is hereby terminated with immediate effect. So, my lord, although they have terminated me, my lord, the protections which are available to a government employee in terms of the Rule 9 of Assam Discipline and Appeal Rules, the entire procedure was flagrantly violated. And number 2, my lord, Article 311(2) makes it very clear, my lord, no person can be removed or reduced in rank except after an inquiry in which he has been informed of the charges against him. That is my basic case. At this stage, I am only praying for notice, my lord.
Mr. Khatoniar, can you terminate the service of the petitioner in this way?
That is why, my lord. One-liner order. One line.
Without
Page-
following any
Page 82.
procedure?
My lord, may issue notice.
So your service has been terminated.
No, my lord. They have terminated me, my lord. Page number 82. They have terminated me. And that is why we have to come before your lordship, my lord.
Why don't you approach immediately thereafter?
I had approached, my lord, subsequent developments were there, and we had withdrawn the earlier writ petition with liberty to file afresh, my lord. And that is how we have filed this. If your lordship kindly turns to page 83, your lordship will see there were two writ petitions, and there were some technical deficiencies, and we had page 80, 84 and 86, my lord. We had filed it, we had withdrawn it with liberty to file afresh.
Heard, Mr.
A.K. Burwa, my lord.
Learned counsel for the petitioner, and also heard Mr. Khatonia
I mean, paying for all the respondents, madam.
for the respondents. For the respondents. This writ petition under Article 226 of the Constitution of India, the petitioner has put to challenge the termination order dated 5/3/2024 passed by the Inspector of School KDC Amingaon. The learned counsel for the petitioner submits that the petitioner was initially appointed as LDA
LDA, my lord.
in Bamundi High School,
Bamundi High School.
and thereafter he was promoted to the post of assistant teacher of Bamundi High School. And thereafter, without following the procedure prescribed in Rule 9 of the Assam
Discipline and Appeal Rules, my lord,
Assam
1964. my lord.
Services Discipline and Appeal Rule 1960.
64, my lord.
64, and also following the procedure prescribed in Article 311 of the Constitution of India,
11(2),
he
my lord.
was terminated from the post of assistant teacher. White impugn. Order dated 5th of March 2024. Let notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Khatonia appears on behalf of all the respondents and received notice. However, extra requisite copy of the petition be furnished to him. Mr. Khatonia shall obtain necessary instruction in this regard and apprise this court on next date. Place the matter after 4 weeks.
Obliged. Deeply obliged.
Item 16.
My lord, a petitioner herein is seeking provincialization of his service, my lord, as assistant professor in a senior secondary school. But my lord, my service was not provincialized as my name was not reflected in the IS code, my lord. I have narrated in paragraph 11 of my writ petition, my lord. I submitted a representation before the authorities. My lord, kindly turn to page 9, paragraph 11. May I read, my lord? That the petitioner begs to state that the representation dated 9/2/2021 filed by the petitioner has not been able to yield any response from the respondent number 2 till date. Therefore, the petitioner recently visited the office of the respondent number 2, wherefrom the petitioner came to learn that the service of the petitioner could not be provincialized as the name of the petitioner does not reflect in a dias code of the school up to 2009-10. It is pertinent to mention herein that the Act of 2017 does not have any requirement requiring the names of the teachers of senior secondary schools to be included in the dias code. Dias code is required for the teachers of LP and ME schools, my lord. As per the provisions of the Act of 2017, there is no such provision, and I have quoted the provisions in my petition. And my lord, I have been told by my friend that a similar matter has been fixed on 28th of November. my lord.
This is a matter similar to item number 9 and 12, my lord. My lord, please to fix the matter on 28, my lord.
28.
28, my lord. So I'll open here also, I'll open instruction, my lord. Why his case was not considered, my lord.
Okay. Heard Mr.
Aaron
Dekka,
Dekka.
learned counsel for the petitioner, and also heard Mr. Khatonia, learned standing counsel for the respondent. All the respondents?
My lord, he
Yes.
will appear for 1, 2, 3.
Except 4, my lord.
4. 4.
1, 2, 3.
Who
Who
do
is
we
for
have?
4?
Headmaster.
Headmaster of the school.
Headmaster. No. Sorry, my lord.
Sorry. Or I have to take steps, madam. The headmaster of the school, madam.
The grievance of the petitioner is that he was appointed a lecturer in the Department of Education at Kalatali Kathami Ansalik Senior Secondary School in the year 2004. Then the district level committee constituted in terms of the provision of Assam education within the provincialization of services of teachers and reorganization of educational institution Act 2017 had recommended for provincialization of service of the petitioner as tutor in the second post. However, service of the petitioner was not provincialized. And on inquiry, the petitioner came to know that his name was not reflected in the Dayas court. Therefore, his services could not be provincialized. The learned counsel for the petitioner submits that as per the provision of the Act of 2017, there is no requirement of reflecting the name of the teachers of Bhansar Senior Secondary School in the Dayas court for provincialization of service. The learned counsel for the petitioner submits that similar matter in connection with in similarly situated matters, the standing counsel for the respondent was directed to obtain necessary instruction, and the matter has been listed on 28th of November, and as such, this matter may also be listed on that day, directing the standing counsel for the respondents to obtain necessary instruction in this regard. There is accordingly allowed. Mr. Khatonir shall obtain necessary instruction in this regard and apprise this court on next date. List the matter on 28th.
Number 17.
Petitioner before your lordship is a music teacher in a high school, my lord. When other staff were, my lord, provincialized, her service was not provincialized on the ground that, my lord, her name is not in the Dayas code. Then she approached before this honorable court, page 55, my lord. And this honorable court, my lord, passed detailed judgment, my lord, holding that, my lord, so far, my lord, teacher in the high school is concerned, my lord, Dayas code is not necessary. And accordingly, my lord, it was provided to consider her claim for provincialization of service as a music teacher in accordance with law, my lord. And page, my lord, 62, paragraph 13 and 14 are relevant, my lord. Within 3 months, it was provided to consider, my lord.
You come to page number 66.
66. Now, my lord, impugn order, my lord, page. I'm challenging the order, page 19, my lord.
The contention is
Page
that
67, my lord.
your qualification in music from
Yes.
Bhatkhande Sangeet Vidyapith cannot be considered as equivalent to other recognized music qualification acceptable to the state of Assam.
Yes, my lord. Now, lordship, kindly have a look, my lord, page 67, it is my impugn order, annexure 19. Here, my lord, they have taken, my lord, reference to another order, and this order is I have annexed, my lord. This is, my lord, page 65, my lord. Here in this case, my lord, why it was, my lord, rejected? Because, my lord, page 65, my lord, in, my lord, impugn order in another case, my lord, lordship, page 65, last paragraph. Further, last paragraph, my lord, I am reading, my lord. Further, as the matter is complex in nature, the petitioners were heard twice, that is on 8/9/2023 and 22/9/2023, and they were asked to produce the documents regarding qualification which are required to get admitted in the Bisharat course and any other relevant documents in support of their claim for acceptance of their qualification. But during the hearing, they admitted that they have not passed the HSSLC or equivalent 10+2 examination. After careful consideration of the above stated fact, it is decided that the petitioner's qualification in music from Bhatkhande Sangeet Vidyapith cannot be considered as equivalent to other recognized music qualification acceptable to the state of Assam. Now, Lordship, kindly have a look. Taking, my lord, note of this order, my lord, my claim was rejected, but petitioner before your lordship not only passed, my lord, metric, he also passed, my lord, higher secondary. I have annexed her, my lord, all the certificates. Lordship, kindly have a look. Page 16, annexure 1 is, my lord, matriculation of the year 1984, and she also passed, my lord, higher secondary in the year 1990, my lord, page 17. Therefore, my lord, this order which was referred in my order is not, my lord, acceptable. That apart, my lord, in this regard, my lord, I have, my lord, annexed another order passed by the, my lord, head of the department, page 69. Lordship, kindly be look here. Page 69, my lord. Here, my lord, Commissioner Secretary passed, my lord, order. Now, therefore, last paragraph, my lord, last two paragraph, my lord. Whereas the government is satisfied that the qualification of HS passed and Sangeet Bisharad from Bhatkhande Sangeet Vidyapith prescribed for the post of music teacher in recognized higher secondary and high school during the period from 1/1/2006 may be taken into account for the purpose of provincialization of service. Now, therefore, in exercise of power conferred by Section 14 of the Assam Educational Institution Provincialization of Service Act 2011, the qualification of HSLC passed and Sangeet Bisharad from Bhatkhande Sangeet Vidyapith from the post for the post of music teacher of recognized higher secondary and high school appointed prior to so and so shall be accepted and a very special case on a one-time basis for the purpose of provincialization of the service under the aforesaid act, my lord. This petitioner before your lordship is also, my lord, appointed before 1/1/2006, my lord. So, my lord, this order, my lord, passed, my lord, page 67, annexure 9, presuming that, my lord, without hearing the petitioner that she has no, my lord, HS, my lord, qualification, but she has, my lord, very much, my lord, HS passed, my candidate, my lord.
Yes, Mr. Khatania.
My lord, we issue notice at this.
My lord, she is going older, my lord. Her age is, my lord. My lord, anyway, my lord, one chance notice is necessary also, my lord. 55 years, my lord, the entire life done, my lord.
Heard Mr. A.M. Borguya, learned counsel for the petitioner, and also heard Mr. Khatania, learned standing counsel for all the respondents.
No, my lord, 1 and 3, then my lord, 5.
1, 3, 5.
And 7.
5 and
No,
7.
no, 7, my lord. 7, my lord, when you will approve.
Lordship 6 and 7, I will be appealing.
Mr. Chaudhary, learned standing counsel for the respondent number 6 and 7. In this great petition under Article 226 of the Constitution of India, the petitioner has solicited correctness of Otherwise of the order dated 22/9/2024 passed by the Director, Secondary Education, Assam. The case of the petitioner is that she has been working as music teacher at Digor Sikuna High School under Kasar district since 30/12/1997, but her service was not provincialized as per Provincialization Act 2017 as amended in 2018 due to non-inclusion of her name in UDICE. Let notice be issued to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1. Mr. Khatone, you are for respondent number 1, 2, and 3.
3 value.
1, 2, and 3. And
Not 2, my lord, 1, 3, and 5, my lord.
1, 3, and 5.
Yes, sir.
1, 3, and 5. And 6 and 7, since Mr. Khatone and Mr. Chaudhary entered appearance and received notice. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks. And in the meantime, Mr. Khatone and Mr. Chaudhary shall obtain necessary instruction in this regard and apprise this for the next step. List after 4 weeks.
In this matter, I appear for respondent.
Respondent number 2. Mr. Barpuzari, Learned Counsel for the respondent number 2.
And so, like,
At number 18.
May I plead your order? Okay, here lordship, the grievance of the petitioner is that lordship his salary is stopped lordship pursuant to lordship departmental proceeding drawn up against him. But that departmental proceeding is drawn up lordship in violation of the procedure prescribed under Rule 9 of the Rules 1964. Why? Because the while lordship may kindly see the statement of allegation, page 32. Lordship, without providing the list of witnesses, these charges have been leveled against me. Annexure 7, page 32. And they have relied upon the evidence of the witnesses, lordship. Number 1, no list of witnesses, no list of documents. Now, lordship, kindly come to page 36, Annexure 9. This is the impugned order. This was issued on 25th October 21, whereby page number 36, Annexure 9. May I read, lordship? With reference to the subject cited above, I am directed to inform you that Authority in Elementary Education Department has carefully examined the inquiry report conducted by so-and-so in context of inquiry into the matter regarding departmental proceeding in connection with the appointment and regularization of services of the 4 number of teachers, namely so-and-so. It is very clearly mentioned in the report that the appointment or regulation order against the 4 incumbents are not genuine, and such force give part of the, on the part of these incumbent cohorts actually, the enforced provision of 1977 rule. So this is the also decision. Considering all these, I am directed to request you to instruct the DO Morigaon to stop the salary of the so-called teachers so and prohibit them come to the school henceforth. Now, my defense is that, Lordship, without Lordship providing the inquiry report, which they have relied on that inquiry report, Lordship, they have come to a conclusion to stop my salary. And also, there is a settled position in view of the Ramzan Khan and also Israel, that inquiry report is a mandatory requirement before that coming to a conclusion, number one. Secondly, Lordship, before the coming to a decision, they have also not provided me second so-called notice also. So without serving the list of witnesses, inquiry report, second.
No, is this the order passed on departmental inquiry?
Yes, yes.
On the report of the departmental inquiry?
Yes, yes, because see, this inquiry report was not furnished to me, Lordship. And this is a mandatory requirement, Lordship. And now, Lordship, the petitioner.
No, is this the final order?
Yes, Lordship. Because pursuant to this order, the Annexure 39 is Lordship issued. Annexure 10 page 39. This was issued by the director. With reference to the subject cited above, I would like to inform you in connection with the letter number so-and-so, the government of Assam, that based on the inquiry made against us, 4 number of teachers, namely so-and-so, the name of the petitioner Abdul Hanan, assistant teacher of Kalikajari English School. It is found that appointment regulation order issued against 4 teachers so-called are not genuine. Accordingly, you are directed to stop salary. So in compliance of these 2 orders, my salary stopped with effect from November 2021. And at the same time also prohibit to come to school. But this order has been issued as pursuant to a departmental proceeding, but they should follow the Rule 9. So without providing any inquiry report, second so-called notice, list of witnesses, they come to a conclusion. Lordship, at this issue notice and the record may be called for, Lordship. Otherwise, Lordship,
Yes, madam.
the petitioner is at the verge of retirement, Lordship.
Notice, madam, I will be allowed to take instruction, madam, whether it has been served to the petitioner or not, madam, inquiry report.
Instead of notice, Lordship, the record may be called for, because ultimately a departmental proceeding. My specific allegation is that no list of witnesses provided, inquiry report is not provided. If inquiry report is not provided, second so-called is not provided, then matter ends there. So Lordship may at this just issue a short notice and record of the proceeding may be called for. Because the petitioner is now.
Madam, you are for all the respondents?
Yes, that's limited department. And he is also suffering from the serious illness, Lordship, at the verge of retirement.
Heard, Mr.
A. Dekar, Lordship.
A. Dekar, learned counsel for the petitioner. Then also heard Miss S. Devi. Learned standing. S.
Sutian.
S. Sutia, sorry. A learned counsel for the respondent member, learned standing counsel for the respondents. The grievance of the petitioner is that he was appointed by the authority of Kalikajari ME Madrasa, and his service was regularized by the DEO Morigaon by order dated 22/11/1999 with effect from 1/3/1999. And after rendering 22 years of continuous service and drawing salary regularly, suddenly a so-called notice was served upon him on 3/8/2018, and departmental proceeding was started against him under Rule 9 of the Assam Services Discipline and Appeal Rule 1964. Thereafter, the proceeding was concluded, and thereafter the Director Elementary Education by order by letter dated 30th October 2021 has directed the District Elementary Education Officer Moregaon to stop salaries of the petitioner along with 3 other persons. Mr. Decker, learned counsel for the petitioner, submits that the departmental proceeding was started against the petitioner in violation of the provision of Rule 9 of the Assam Services Discipline and Appeal Rules 1964, and that no list of witnesses and list of documents were furnished to him, and no no second so-called notice was served to him after conclusion of departmental proceeding and before imposing the punishment. And as such, Mr. Decker contended to issue notice to the respondent and to call for the record, relevant record. Having considered the submission of Mr. Decker, learned counsel for the petitioner, and also the submission of Ms. Sotia, learned standing counsel for the respondent, it is provided that notice be issued to the respondents, returnable in 2 weeks.
3 weeks, madam.
3 weeks. However, no formal notice is required to be issued since Ms. Sotia entered appearance on behalf of all the respondents and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. It is provided that Ms. Sotia shall produce the record of departmental proceeding before this court on next day, along with necessary instruction.
Lordship, she was suspended. The petitioner filed a petition to revoke the suspension order, and it was revoked, Lordship. Lordship, by the order dated, may kindly go to the order, page number 19, Lordship. Made it. Peruse, the report submitted by DU Nagaon Violator dated 12/10/2023, and also peruse the enquiry report submitted by the enquiry committee constituted by this office under so-and-so, dated so-and-so. Finding, it appears that Srimati so-and-so headmistress of Docking Jarwagan LP School under DU Kothiatul was placed under suspension by the order dated so-and-so, dated so-and-so, on the ground of incident 72 number of students who were felt illness with symptoms of vomiting and stomach pain after consuming MDM at Docking Jarwagan LP School under BO Kothiatul so-and-so, due to food poisoning, and the sample of conformity of food poisoning was tested positive for detergent and has potential deleterious effect on human health as per report of Food Safety Officer Nagaon. However, all students were survived after medical aid without critical illness. Now the Lordship order. In view of the fact, Srimati Swarnali Pathak under suspension, headmistress, Docking Jarwagan LP School under BO Kothiatul was placed under suspension by order under memo number so-and-so is hereby reinstated by concluding DP in her original place of posting with a stoppage of 1 increment without cumulative effect, provided that the senior most assistant teacher is allowed to act as in-charge headmaster in place of Srimati Swarnali Pathak to maintain healthy academic environment in the school with a person not to act such type of activities in future. As if departmental inquiry was conducted behind my back and punishment was given, Lordship, that inquiry person not punished to me, Lordship.
You have not participated in the departmental
No,
proceeding?
Lordship. Therefore, Lordship, I have written a letter to the Lordship. Can you say page number 20?
No, you answer my question whether you have participated in the departmental proceeding or not.
No, nothing.
No.
Therefore, Lordship, page number 20, Lordship. With due respect, I beg to inform you that it was informed to me that one increment was stopped and in-charge headmaster was withdrawn on the basis of inquiry report and so. But what inquiry report? I don't know, Lordship. Behind my back, Lordship. If there is an inquiry report, Lordship, There is two inquiry, Lordship, earlier additional deputy commissioner. That inquiry I have participated, Lordship. That inquiry, Lordship, on the basis of that inquiry, this department person was not made, because 5/12/2023, it's another inquiry. What inquiry, I don't know, Lordship. Therefore, I have given, Lordship, because it has to be provided to me. On the basis of you have given punishment to me, Lordship, by cumulative effect, not two punishment, Lordship. My in-charge headmaster has been also curtailed by giving a tutor, Lordship. It cannot be also, because tutor cannot be in-charge headmaster. There is a law, Lordship.
Yes,
However,
madam.
in this case, Lordship, notice may go, Lordship.
This is notice made.
Notice may go, Lordship, because there is a private listener.
What is the relevant record? Heard Mr. Mohanto, learned counsel for the petitioner, and also heard Ms. Sutia, learned standing counsel for the elementary education department. The grievance sought to be addressed in this writ petition is that the petitioner was working as headmistress of Dokhin Zarbagan LP School under BEEO Pothiatole. She was placed under suspension by order dated 31/5/2023, memo number EAA/B/108/2023/24-A, in connection with an incident of food poisoning of the students of our school. On 17/5/2023. Thereafter, by order dated 5th of June 2024, she was reinstated. No. Oh, yes. She was reinstated by conducting a departmental inquiry, departmental proceeding, and the punishment of stoppage of one increment without cumulative effect was imposed upon her. And also, the next senior most assistant teacher is allowed to act as in-charge headmaster in her place. Mr. Mohanto, learned counsel for the petitioner, submits that the departmental inquiry was conducted behind the back of the petitioner, and she has filed on a representation for furnishing the inquiry report dated 5/12/2023, but same has not been furnished to her. And that the impugn order of imposing punishment is illegal and arbitrary, and therefore it is contended to set it aside. The submission of Mr. Mohanto, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered. No, however, no formal notice is required to be issued since all the. Madam, we were not representing the respondent number 4, perhaps.
I'm 1, 2, and 3, madam. Okay.
However, no formal notice is required to be issued to the respondent number 1, 2, and 3, since Mr. Sutia, learned standing counsel for the department, entered appearance and received notice. Notice to the respondent number 4 be issued by registered post with AD and also by usual process within a week from today. Place the matter after 4 weeks. In the meantime, Ms. Sutia, learned counsel, standing counsel for the respondent number 1, 2, and 3, shall produce the relevant record before this court on next date, along with up to date status.
In this way,
No, along with instruction.
I'm paying for extra copies. madam.
Publish.
Yes.
I will.
Ordered.
Item number 20.
The extra copy, the column.
May please, Your Worship. Here the petitioner is praying for promotion from grade 4 to grade 3. Lord. Lordship, he has preferred an application on 12/10/2022. Lordship. And after that, Lordship, Annexer 4, page 16, Lordship. A elect committee was constituted.
Recommended you.
Lordship?
Select committee has recommended you.
Yeah, recommended.
Then the matter is pending before the
Pending before the Lordship, respondent number 2, Lordship.
respondent number 2.
2. Lordship.
Then you have filed on representation.
Yes, Lord.
And no action has been taken upon the same.
No action has been taken upon that.
Yes.
Lordship, before that, I want to point out one thing, Lordship. Annexer 8, page 24, Lordship. Because of this,
it has been clarified, Lordship, Annexer 9, Lordship.
that, but I want to, that was not challenged, Lordship. In the prayer position, the other thing, there's not challenged. That letter, Lordship. Thereafter, college will say again, proceeded and then it is.
It's a sequence of events, Lord. It's a sequence of
I
events.
just pointed out this, that is a relevant one, Lordship. He have not challenged. The prayer position, nothing regarding this. Lordship. The vital one, Lordship.
So whether he is in the 25% of the post.
Lordship, at present, notice maybe you should, I will take injunction, Lordship, presence.
Or we can dispose of this petition directing the respondent number to dispose of his
Yes,
representation.
Lord. Yes, Lord. Yes, that can be done. That can be done. The time limit. That can be done. Lord.
What do you want?
Lordship,
That can be done. Ultimately, the director will take decision, Lordship.
yes, Lord.
That can be done, Lordship.
Heard Mr. S. J. Sharma, learned counsel for the petitioner, and Mr. Bhuya.
Yes, Lordship, as Bhuya, Lordship.
S. Bhuya, learned standing counsel for the
I
respondent.
1 and 2.
Respondent number 1 and 2. The grievance of the petitioner, this is sought to be addressed in this red petition, is that he was appointed as office attendant in grade 4 on 3/8/1995, and since then he has been rendering service for more than 20 years. And on 12/10/2022, he preferred an application to the principal, Moran College, Maranhat, for taking initiative for his promotion from grade 4 to grade 3 post, as he is the senior most and qualified to be promoted. Thereafter, a meeting of the screening committee was held on 5/12/2022, and the petitioner and the proposal of the petitioner for being promoted from grade 4 to grade 3 was approved. And the said committee also resolved that the name of the petitioner be recommended to the Director of Higher Education as per approval of the rule. Thereafter, the respondent number 3, the principal of the college, has forwarded all the relevant documents to the respondent number 2 to take initiative for approval of the promotion of the petitioner. But the respondent number 2 has not yet taken any decision upon the proposal forwarded by the respondent number 3 for a long time. Mr. Sharma, learned counsel for the petitioner, submits that the petitioner has submitted the representation on 27/8/2024. To the Director of Higher Education, Kahilipara, Guwahati. But no action has been taken till date. And accordingly, it is submitted that this writ petition may be disposed of by directing the respondent number 2 to dispose of the representation of the petitioner dated 27/8/2024 within a period of 1 month. Within a period of 1 month from the date of receipt of certified copy of this judgment and order. The learned standing counsel for the respondent number 1, 2, and 3, 1 and 2 also conceded to the submission so advanced by Mr. Sharma, learned counsel for the petitioner. Having considered the submission of learned counsel for both the parties and also considering the facts and circumstances in the record, this court is inclined to dispose of this writ petition by directing the respondent number 2 to dispose of the representation of the petitioner dated 27/8/2024 within a period of 1 month from the date of receipt of certified copy of this judgment and order by passing a region order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 2 within a period of 1 week from today.
Regarding Annexure 8, it is something also I have submitted also, and that's Annexure 8 also. Once, considering this also, I have submitted that this also.
Annexure
8 lawsuit. Annexure 8 and Annexure 9 lawsuit, something regarding Annexure 8 and Annexure 9.
8 and 9.
No, we are not disposing of the petition on merit.
Lawsuit, once it was rejected, thereafter college authority again approached lawsuit.
This was approached because
that the authority not that considered lawsuit, that the authority once considered lawsuit. Therefore, again college authority.
No, we are only directing to dispose of this representation.
Only that, if that's something I have just submitted, only this.
Because
only this
observation was made, Lordship, it was clarified in Annexure 9.
This is the college authority, that authority is the government lordship. Director lordship. Yes, once decision is taken lordship, it's a reconsideration now. After, okay, you file a that's defending. But once decision is taken lordship, but he has not challenged this. That's the problem lordship. That's why I initially pointed out.
Lordship, this has not been challenged because, Lordship, Annexure 9, it has been clarified, Lordship. They have said that 4 posts are there. In Annexure 9, it is clarified by the respondent number 3 that there are 5 posts. This decision has been.
This if 4 posts are there, then 75 is to 25.
Yes,
1 post will go to.
That's clarified lordship that both.
This has been clarified that 5 posts are there, Lordship.
That's only
And 1 post is vacant.
Department has taken decision lordship. But that decision is not challenged lordship. Thereafter, college again that decision number, but only reflect this.
No, is it necessary? Because we are not entering into the merit of the petition. No? We are only directing to dispose of this representation by a speaking order.
That's not also, but the representation on submitted on 27/8/2024. After rejecting this, the college again placing lawsuit. That's why I am submitting. Because already the department has taken decision lawsuit. Not that they take decision, Lordship. That decision they have not, here not selling.
After that has been
Yeah, that's
clarified on
only-
11/3 that the post regarding post, there is 5 posts. And one is still vacant.
No, this annexer 8 is clarified in annexer 9
9 Lordship,
that there are 5 posts.
5 posts. Lordship.
Considering this, Lordship.
No. They will consider it. Since we are not entering into the merit of the petition, we will not discuss
okay,
all
okay.
this.
In the meantime, Lordship, the vacant post may not be filled up.
No,
Through an
no,
advertisement.
not that, Lordship. Oh, it is.
No, we are
position of-
directing to dispose of the representation within 1 month from today.
Yes,
In the meantime, the vacant post may not be filled up.
Lordship, nothing.
Because
No,
there is
no.
a vacant post for.
There's no-
Is there any likelihood of filling up
No,
the
no.
vacant post?
In the petition, does not say anything, Lordship.
Lordship,
Regarding fill up.
I have prayed for interim period, Lordship, page 11.
That's
Lordship.
true, but no.
Page
I-
11, Lordship. I have prayed that in the interim disposal of the repetition, I direct the respondent not to fill up the vacant post of laboratory assistant lying vacant in the office
Okay,
of.
till
respondent.
disposal of the repetition of the petitioner, no vacant or no post lying vacant in the Moran College shall be filled up in grade 3.
Number 22.
My application. Here in this case, the petitioner is praying for his promotion to the post of administrative officer, which has been denied to him in view of a certain communication which has been challenged before this honorable court. It is at page number 35, annexure 10 lawsuit.
What is the qualification for the post of administrative officer in SCRT?
Lordship, what they are stated here is that the tenure of 2 years has not been completed from the feeder. So the fact is that why you have challenged this particular order in view of there's a certain rules that have annexed at annexure 11, this page number 36, Lordship. Even they have also admitted that aspect of the matter, the Assam rules of executive business. Assam rules of executive business, the personal B branch. The Lordship kindly see the next page, page number 37.
No, what is the tenure of your period as a?
2 years, Lordship. What?
No. The experience required
2 years is required from the feeder post, Lordship.
in your tenure?
I'm just 1 year, some few months, Lordship. So for that reason, Lordship, I submitted my representation also. If your Lordship kindly see my representation, which will clarify the entire aspect of the matter.
At
And
page
also
number?
the proposal sent by the director of the.
At page number?
Page number 28, Lordship, annexure 6. Annexure 6. Where I've expressed all the grievance, the promotions which I ought to be given to the petitioner that was denied during the relevant period of time, and because of which there's some this deficiency in the tenure, Lordship. Lordship, kindly see the operative portion with regard to the representation. It's page number 29, Lordship. Sir, as per Rule 6(1) of the Assam Directorate Establishment Ministerial Service Rule, recruitment to the post of administrative officer shall be made by the promotion from the select list approved by the commissioner for the purpose under sub-rule 4 from amongst the members of the service holding the post, register or superintendent in any of the office for a total period of not less than 5 years. Sir, I am going to retire on superannuation from service on 31/12/2024. It is learned from reliable sources the Secretary Administrative Department of Government of Assam has been promoting the eligible register of the directorate to the post of administrative officer available in a few of the directorate in the state, counting, adding the service experience. So that has been done, Lordship. Gained by in both the post of superintendent and register as per the Assam Directorate Establishment Ministerial Service Amendment Rules 2020-2002. Considering the coming date of my retirement, the long period of my service rendered in the post of UDA, your honor may kindly be pleased to move the personal B department. So that was the prayer made, Lordship. Personal B department to the government of Assam to relax the service experience required for my promotion to the next higher post of administrative officer. So that has been, even that communication is there, Lordship. If your Lordship kindly see this annexure 8, page number 32. Page number 32, Lordship. Regarding proposal for filling up the post of administrative officer, that is the communication from the under secretary to the concerned director SCRT Lordship. In the last paragraph, Lordship, if your Lordship kindly see page number 32.
Mm.
Now you are hereby requested kindly to furnish detailed information about service history of Prabhat Chandra Das, registrar, along with proper justification for onward submission to personal B department for relaxation of qualifying service. So that relaxation part is always there, Lordship. That can be considered in view of the long tenure of service of the petitioner. Lordship, kindly see the next.
You have filed a representation?
Yes, Lordship, the representation is there, Lordship, which I
When?
just now, which I just not shown, Lordship.
Mm.
That was in the month of November 2023, but thereafter no action has been taken with regard to that.
November?
2023, Lordship, is page number 28. In that
And
particular,
what action was taken upon the same?
Lordship, no communication has been made with regard to this particular representation. Although the proposal has been said from the side of the director, Lordship, SCRT, to the concerned authority. But by this impugn order, that prayer for sending to the personal B department, there is no communication. But in view of the tenure with regard to the feeder post of registrar, that has not been taken into account. So I've just now shown that annexure 10, Lordship, page number 35. Page number 35.
Mm.
Page number 35, annexure 10, Lordship. Annexure 10. In inviting reference to the subject cited above and directed to convey regarding your proposal for filling of the post of administrative officer of SCRT Assam by way of promotion from their feeder post of registrar, that as the lonely incumbency Prabhat Chandra Das, registrar SCRT Assam, has not entitled due to non-fulfillment of required tenure, that it may be required for the said promotion. Now the tenure part, if your Lordship kindly see the tenure part, is in page number 38, Lordship.
Hmm.
Page number 38. The administrative officer, recruitment to the post of administrative officer shall be made by the promotion from the select list approved by the commission for the purpose under sub-rule 4 from amongst the members of the service holding the post of registrar or superintendent in any of the office for a period of not less than 5 years on the first day of the year in which selection has been made. So the registrar or superintendent, both posts is there, Lordship. When I am holding the post, previous to the registrar, I was holding the post of superintendent. So in that view of the matter, Lordship, the proposal that can be sent to the personal B department for considering the case of the petitioner in view of his long-standing this service. So that is the limited prayer before this honorable court, Lordship, considering the early date of superannuation, Lordship. My learned friend can obtain the instruction with regard to that, whether that can be considered or not, Lordship. This is the simple prayer that I made in this situation, Lordship.
Yes, Bora?
But SCRT is a made party and copy has not been served, madam. I have just received the copy. I have taken the copy, court copy, I mean. But so I have seen the notice also, copy has not been served. I need to get the instruction.
The Lordship, this can the matter be fixed on day after tomorrow, Lordship, so that on Friday.
Day after tomorrow.
Day after tomorrow, Lordship. I'm applying the instruction. I will give a copy. I will give you extra copy, Lordship.
And Lordship will show the name of the SCRT standing council. in the
I will give you extra copy.
Standing counsel for SCRT?
Yes, I am the standing council, but I have been
You are?
informed, yes, but the copy has not been served. madam. I have even checked the notice also. Nobody has taken.
Okay.
It's a mistake on my part, Lordship. I will correct it. Today I will serve a copy to you.
Heard this,
Today I will serve a copy.
SP Sodure, learned counsel for the petitioner, and also Mr. S. Bora, learned standing counsel for the respondent number 1, 2, and 3, and 4. 1 and 2. Your good name, please? Pardon?
M. Fukan.
For the respondent number 1 and 2.
1 and 3.
Okay, and Mr. Bora for respondent number
4.
Respondent number 4.
Finance is also there.
Finance is there, Lordship.
But B Google will appear for finance. 2.
Finance department. Okay. And Mr. Gogoi, learned standing counsel for the respondent number 2. Mr. Bora, learned standing counsel for the number
Number
4 submits that he has not been furnished with a copy of the petition. Mr. Sodhuri, learned counsel for the petitioner, undertakes to furnish a copy of the
Today itself, Lordship. I'll serve a
petition
copy.
during the course of the day. List the matter day after tomorrow.
Day after tomorrow, Lordship.
In the meantime, Mr. Bora shall obtain necessary instruction from the concerned department.
Obliged, Lordship.
Item 23.
May praise the Lord. My lord, the petitioner is very nice, my lord, are trained undergraduate teachers, my lord. And they are trained undergraduate teacher and they are serving under the respondent number 2, that is the Director of Elementary Education, and they are discharging their services as LP school teachers. Here, my lord, our grievance is this, my lord. The initial payment.
Now you tell me whether the anomaly report of the anomaly committee was accepted by the government or not.
That, my lord, instruction, my lord, I don't have, my lord.
Then,
my lord, at our grievance is in respect of, my lord, initial payment, my lord, and this is in respect of grade pay. We have no grievance in respect of grade pay. Initial payment, we have been given as rupees 14,000, whereas the similarly placed teachers, they have been given 15,900, my lord. So our grievance is this, my lord, since we are rendering this equal nature of service, so we may also be given that amount, my lord, as 15,900, my lord.
so admittedly, you are not a graduate teacher.
Yes, my lord, we are, my lord, a trained undergraduate teacher, and if lordship turn to page 25, it is a part of a notification of the finance department, which starts at page 24. Page 24 relates to the teachers of ME school. And since, my lord, we are the teacher of LP school, page 25 will be applicable, my lord. Page 25, the heading is LP Junior Basic Pre-Primary School. That name of the post, number 2 column, my lord. Untrained graduate teacher, including trained undergraduate teacher. So untrained graduate teacher and trained undergraduate teacher are of at par, my lord. And their grade pay.
No, grade pays are different.
Grade pay 6,800, my lord. Column 2. Under the heading grade pay, this is 6,800. We are getting 6,800. But, my lord, at initial payment, we are now getting 14,000. That lordship will get in that page only, my lord. That's 1, 2, 3, 4, fourth column, my lord, 14,000. At paragraph 7 of my writ petition, my lord, I have stated this fact, my lord. If lordship comes to page 6, paragraph 7. May I read, my lord? That the petitioners recently came to learn that in respect of similarly placed graduate untrained lower primary school teachers who had entered into service on or after 1/4/2016 and before the date of publication of ROP rules of 2017, that is 17/3/2017, their pay band has been revised to rupees 15,900 plus grade pay to 6,800. Pursuant to a note submitted by the Deputy Secretary of Finance PRU Department on 9/5/2022. The petitioners requested that the respondents have fixed the initial pay of the similarly placed untrained graduate teachers of lower primary schools in the revised pay as per the Assam Service Revision of Pay Rules 2017, with effect from the date of their joining in service in terms of the aforesaid note dated 9/5/2022, which is after the date of joining of the petitioners in service. We were appointed on 27/3/2017. These untrained graduate teachers and graduate untrained teachers are of same nature, same classmate.
Yes, madam.
Notice, madam.
Pardon, Mr. Adam Decker, learned counsel for the petitioner, and Ms. S. Sotia, learned standing counsel for the respondent number one,
and
two,
two,
and
my lord.
He is finance department,
Yes,
my lord.
finance, fine.
one and two. In this petition under Article 226 of the Constitution of India, the petitioners have right for issuing direction to the respondents to fix their initial pay in the pay band at the rate of rupees 15,900 from the date of their joining in service, which has been paid to the similarly placed graduate untrained LP school teachers who had entered into service on or after 1/4/2016 and before the date of publication of ROP rules of 2017, come up from the date of their joining in service. First, the petition and the documents placed on record, let notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 3 be taken by Mr. Gogo is here.
My lord.
I will
Is
serve him a
this
copy,
getting
my lord. I will serve him a copy, my lord. B. Gogoi.
You have served,
I will serve, my lord.
you will serve.
My lord.
Okay. Will you record his presence
My
now?
lord, my lord.
However, no formal notice is required to be issued since also heard Mr. Gogo. No formal notice is required to be issued since all the respondents are represented by the standing counsel. However, extra requisite copy of the petition we furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, the learned standing counsel for the respondents shall obtain necessary instructions and place the same before this court on next date.
Reply obliged.
Item 24. Please, your lordship, pray for timing of this matter, your lordship.
Okay.
Item 61. This matter relates to my admission in NEET PG 2024, lordship.
Your admission in?
NEET PG, lordship.
Hmm.
After completion of MBBS, lordship, I sat in the examination conducted for that admission into the post-graduation course, lordship.
Hmm.
And therein, lordship, may kindly turn to page 26, lordship. Lordship will find that Roman number 12, 11, lordship, I secured 77.5 marks, lordship. Now, lordship, I am claiming that PG seat under state health quota, lordship. And I preferred an application before the authorities for granting me no objection certificate for admission into that course, lordship. The application was pending and this court protected me in the meanwhile, lordship, when I approached. Now they have filed an affidavit.
So you have appeared in counseling process?
No, my lord, counseling has not started yet. It has
Acha.
notified, my lord. It has been notified now.
Hmm.
So it will start,
From today itself, the first round of counseling will start, lordship. It will not start, but the registration process
registration will start, my lord.
Now, in their affidavit, lordship, the grant of NOC in my favor has been rejected. And they have annexed the rejection order, lordship. That lordship will find at page 51. This, as your lordship got it,
Page number?
51.
Yes.
Lordship will kindly peruse the subject matter. Rejection of NOC application for pursuing fellowship program under SSUHS session 2024-26 in respect of Dr. Shahbaz Hussain, Bhagyapur MPHC Golaghat. Now, Lordship, I prefer two applications. One for grant of NOC for pursuing this fellowship program and the other for pursuing that NEET PG 2024. This apparently was the rejection order of that application pertaining to grant of NOC for that fellowship program, Lordship. This does not relate to the NOC for the
NEET PG.
Lordship. But now, today, Lordship, my friend has given me a copy wherein, Lordship.
And I have produced before your lordship also that copy. Yes, my lord. On the same ground, my lord, the two rejection order is there actually, my lord. Today I have been communicated with this order, my lord. The ground is same, my lord, because the department rejected the application of the petitioner on the ground that, my lord, because the petitioner has to be, if your lordship comes to page 44 of the writ petition, my lord. This is the guideline, my lord. My lord, 44 in clause 2, my lord. The last line, your lordship will find the NOC would be issued only to candidates eligible for grant of study leave EOL, study leave or extraordinary leave. So, my lord, as per the provision of the leave rules, my lord, study leave, if employee eligible for study leave, if he completes 3 years of continuous service. And in the instant case, the petitioner joined in service on 10/1/2022, my lord. 10/1/2022. Prior to that, he was under the service of NSF. But in government service, he joined on 10/1/2022, my lord. So
Earlier, he was in NSM.
under
NSRM.
NSM, my lord, NSM. Joined on in the on 11/1/2022, my lord. 11/1/2022. In my affidavit, I have stated it.
11/1/2022.
So as such, he has not completed the required eligibility criteria of continuous of 3 years of government service, my lord. And therefore, he is not eligible for grant of study leave, my lord. And since he is not eligible for grant of study leave, so, my lord, NSC has been rejected, my lord. That is the main crux of the matter, my lord.
Is there any provision for relaxation?
That provision is not there, my lord.
May I submit, Lordship? Lordship will kindly peruse these rules, leave rules, Lordship. The Lordship got that. Lordship, he is relying upon Rule 14 of the leave rules 1934, Lordship.
Correct. My lord, the relevant portion is there, my lord. I am relying on 14.24.
Prior to that, Lordship will read 14.1, Lordship. Extraordinary leave without allowance may be granted to any officer in special circumstances. Number A, when no other leave is by rule admissible. Or number B, when other leave is admissible, but the official consent applies in writing for the grant of extraordinary leave. Meaning thereby, Lordship, when no other rules is applicable for grant of leave, then only I can avail the benefit of this extraordinary leave. Or in the other case, if I apply, then only they will grant me this extraordinary leave. Now, my application, Lordship, may kindly see once that Lordship will find at page 41.
Yes.
With due respect and humble submission, I would like to inform you that I have successfully qualified in the recently conducted NEET PG 2024 exam, and my name has been included in the counseling for postgraduate degree and diploma courses session 2023-24. according to the regulation of admission into postgraduate degree and diploma courses rules 2021, I have completed more than 5 years of continuous service under the government of Assam and thus received an experience certificate countersigned by Director of Health Service, Hengrabari, 2036. Therefore, I request you to kindly issue me a no objection certificate from your end and thus oblige. So there was no whisper about the grant of extraordinary leave, Lordship. And they said that they can give me grant and extraordinary leave under this provision, Lordship. So my humble submission is that this provision is not applicable in my case, Lordship.
So Mr. Bora, you see this, he has completed 5 years service.
My lord, he is going to avail the study leave. And the provision under clause 14(2)(4), it deals with the study leave, my lord. The other leave, extraordinary leave or other leaves are different. But for the study leave, my lord, this is the requirement. 24 months. 24 months, 14.2. Roman 4, my lord. 24 months where the leave is required for the purpose of prosecuting studies certified to be in the public interest, provided the government servant concerned has completed 3 years continuous service on the date of expiry of leave of the kind due and admissible under the rules, including 3 months extraordinary leave under so. So he has to complete 3 years of continuous service. And what does this continuous service means, my lord? If you comes to first page, my lord, for the rule 3, my lord, 3.8, the definition of completed years of service is there, my lord. Rule 3.8, completed years of service and the 1 year's continuous service means continuous service of the specified duration under the state government. So he is under the state government with effect from 11/1/2022 only, my lord. So 3 years continuous service has not been completed by the petitioner, my lord. And because of that, my lord, the NOC has been rejected, my lord. Because in that guideline also, if your lordship again peruses page 44, my lord, the NOC would be issued only to candidates eligible for grant of study leave. The candidates who are eligible for grant of study leave. So NOC will be issued to those candidates only. So in terms of this rule 14.2 Roman 4, my lord, he is not eligible for grant of study leave. So NOC cannot be granted, my lord. Even if NOC is granted, my lord.
This OM is in respect of granting NOC.
Yes, my lord. Even if, my lord, NOC is granted, my lord, he will not be able to join the course, my lord, because he will not be granted study leave.
Lordship, there is another rule by the name Assam Study Leave Rules 1963, Lordship. That is applicable in my case. My humble submission will be that.
Read that rule. Let us evaluate.
Lordship will kindly let us this. Yate ase, ekhon lights.
Yes.
Lordship, that rules 1963 at Rule 3, Lordship will kindly pay rules. Rule 3. Under that provision, Lordship, study leave can be granted for 24 months, Lordship. Rule 24 says for 24 months. But this PG course is of 36 months, Lordship. And that provision itself says, Rule 4, Lordship, itself says that if in case the study leave is required for a longer period than 24 months, then other leave is to be combined along with that, Lordship. So, Lordship, here in Lordship, in the office memorandum, they have stated study leave or extraordinary leave, Lordship. In case there is a combination of those leave rules.
So you are referring to Rule 3 here.
Rule 3 says that I am eligible for that study leave, and Rule 4 says that maximum period would be for 24 months. In case it exceeds 24 months, it would have to be combined with other leave, Lordship.
No, but this NOC has to be issued in your favor.
Yes, Lordship, I am eligible for grant of leave, study leave, Lordship, and these rules are the rules under which I am
No,
eligible.
provided they have issued a NOC to you.
The notification which my friend referred to says that NOC is to be granted if I am eligible for leave under the leave rules or eligible for leave or extraordinary leave, Lordship.
Study leave.
Study leave. Study leave is under these rules. Lordship.
There's a 3 years continuous service.
That continuous service, if Lordship peruses that extraordinary provision relating to that extraordinary leave, Lordship, that is 14, Rule 14, 2, Rule 14(2)(4. Lordship will read it once again, Lordship. 24 months where the leave is required for the purposes of prosecuting studies certified to be in the public interest, provided the government servant concerned has completed 3 years continuous service this is important, on the date of expiry of leave of the kind due and admissible. On the date of expiry, Lordship. Now I have already completed, that is here, Lordship. That is to be considered, Lordship. Now I have completed already around 2 years, 8 months of service, Lordship. Now, upon grant of leave for 24 months and expiry thereof, Lordship, I have completed more than 3 years, Lordship, obviously. But they are rejecting my case, Lordship, on this basis. Lordship. I would say that this is not applicable, Lordship, but then even if it is made applicable, Lordship, they could not have rejected when it clearly says that on the date of expiry, the period has to be counted, Lordship. Whereas they have counted it from the beginning itself, Lordship. That cannot be, Lordship. From the beginning itself, they have counted a period of 3 years.
Yes, Mr. Bora.
My lord, because the rule clearly says, my lord, that for grant of NOC, he has to be eligible for study leave. And these leave rules, my lord, the provision says that, my lord, when the government servant completed 3 years of continuous service, then only he will be eligible for study leave, my lord. And 14.2(4), it clearly says, my lord, 24 months where the leave is required for the purpose of prosecuting studies certified to be in the public interest. So only this provision is related to study leave, my lord. So he has to be eligible for the study leave.
It is
Provided the government servant concerned has completed 3 years continuous service on the date of expiry of leave of the kind due and admissible under the rules, including 3 months extraordinary leave under Swencho. So the last part means that in the meantime, if he has availed any extraordinary leave of the leave or any leave, including 3 months leave, so that will be also counted for the purpose of calculating that 3 years of continuous service. So that means, but otherwise also, my lord, if he joins the duty on 11th of January 2022, even if he has availed any leave, we are not considering that. We are not taking into account that aspect, my lord. Otherwise also, even if this period has been considered as his continuous service, 3 years is not completed, my lord. 3 years will be completed in the month of January 2025 only, my lord. So he is not eligible, my lord. Because today, my lord, if he, because in terms of the interim order passed by this honorable court, if he participates in the counseling process, if he is selected, if he is admitted, but if NOC is not granted by the state, my lord, so how he will, NOC or study leave is not granted, my lord, how he will perform his course, my lord. He will not be in a position to continue pursue his course, my lord.
Lordship will kindly
So
say
it
one
is
thing,
because,
Lordship.
and this, if your
said
lordship or lordship peruses the first line of the office memorandum as 44, my lord, then your lordship will find, because why this office memorandum was issued? It has been observed that some medical officers who are serving under Health and Family Welfare Department do not obtain NOC from the government before applying for pursuing postgraduate degree diploma courses or any other such training courses on the presumption that subsequently the study leave UOL would be granted automatically. However, the eligibility conditions for study leave UOL are different from that required for eligibility for the state quota in PG admission, because there were a situation where, my lord, the students appeared, they are selected, they took admission, but subsequently the study leave was not granted, they could not pursue their courses, my lord. And that's why this notification was issued. And this condition has been, because of that purpose, it has been stipulated here. The NOC would be issued only to candidates eligible for grant of study leave UOL, my lord. So it is simple case, my lord. If he is not eligible for study leave,
NOC cannot be granted.
NOC cannot be granted because he cannot pursue his course, my lord, even if he is selected.
Lordship, for grant of
Being a
study
state,
leave,
being a
there is another set of rules, Lordship. Therein the requirement is for 5 years, Lordship. That 1964 rules that I referred to, it says that 5 years you need to serve for the government, Lordship. That I have, Lordship. They have no objection with regard to that. Even the joint director and director had certified that I have completed 5 years of service under the government. But that permanent employee thing, Lordship, they are hesitant with that, Lordship. But then, even if they apply that, the question would be, Lordship, is that extraordinary leave not applicable to non-permanent employee, Lordship? It is applicable, Lordship. Then the provision itself says, Lordship, that rule 14.2, it starts with the word except, Lordship. So meaning thereby, it is made applicable to all other employees except the permanent employees, Lordship. The permanent employee would gain the benefit of that extraordinary leave with any condition, Lordship. But then for the non-permanent employee, this provision is being made applicable, Lordship. Lordship, then my other submissions are that, Lordship, I would be eligible for this grant of leave. There is a schedule, Lordship, which has been prepared on all India basis, Lordship, by the third round of the counseling, Lordship. I would become eligible by then, Lordship. There is a shortage of only around 45 days or something like that, Lordship. So the problem with me is that if I get a chance then I would not be able to get my preferred subjects, Lordship. But then they would not have applied these rules, Lordship, in my favor and denied me this opportunity to get the counseling from the beginning of first round itself, Lordship.
So by that time, you take admission in the courses, 3 years period will over. Is it your submission?
No, that is not his submission. His
Submission is that by the time I complete 3 years, Lordship, I will be eligible for the third round of counseling. But they are not considering it for the first round, Lordship. That is another submission, Lordship. They are
What he is trying to submit, if your lordship come to page 63, my lord. There is a schedule, my lord. So in the schedule, my 63, my lord. So first round of counseling is from 20th September.
The state counseling
18 November to 2024 to 27 November, first round of counseling. Then second round of counseling from 12 December to 23rd December, point number 3. And stray vacancy, my lord, point number 7, my lord. State counseling 25th January to 30 January. So he is saying that for the third round of counseling, he will be eligible. But the question is that whether seat remains or not. Because first round of counseling, after completion of the first round of counseling, if seat remains, then there will be second round. And even after the second round, if seat remains to be
only then there will be third round.
Only the third. But so that is called stray vacancy, third round of counseling. If it is available, only in that case. So
My
at this
submission
stage,
is
my
that
lord,
they have interpreted the provisions wrongly, Lordship, and Lordship will interfere to the extent that these extraordinary rules, Rule 14.1 and Rule 14.2 cannot be read separately, Lordship. It has to be in cognizance and read together, Lordship. Only when other leave is not applicable, then only extraordinary leave for the purpose of study is to be granted, Lordship. And I have never applied for extraordinary leave for study.
No, then the question is, you are not a permanent employee.
I am a permanent employee, Lordship, now, but that period they are requiring is that it must be 3 years of permanent service. I have served for more than 5 years, Lordship. I have
No,
served
but for initial,
for NHM, Lordship. Thereafter, APSC selected me and I was given permanency, Lordship.
so whether the earlier period will be counted?
no, my lord.
For the state health quota, it has to be counted, Lordship. The
Clause
rules
3, my lord, I have
rules
pointed out,
itself
my lord.
says, Lordship, I'll just
Clause 3 of the legal
just
rules.
refer to those rules, Lordship.
Clause 3, my lord, completed years of service, my lord, space. So it says, my lord, completed years of service and 1 year's continuous service means continuous service of the specified duration under the state government. So not any other agency, my lord, NSM or any other agency. So under the state government.
Lordship,
3
will
years.
kindly turn to page 31. Page 30. Rule 7C. State health quota seats. 40 seats, 37 degree and 3 diploma out of total state quota seats shall be reserved in each session for the doctors appointed in the state health services on regular basis on the recommendation of the APSC, MHRB, and who have completed 5 years or more service in rural areas. So that 5 years was the requirement for availing the benefit under the state health quota. Now I have completed that period of 5 years service, and the director, joint director has already certified that. That Lordship will find at page 40.
Page? Page number?
40, Lord.
Yes.
This is to certify that Dr. Shahbaz Hussain has been working in regular service in Bhandara Chart PHC, situated in Bhandara village under Manipur BPHC, under Abhaypuri State Dispensary, situated at Abhaypuri village under Sirangram BPHC, both in the district of Nagaon of Bongaigaon, Assam, with effect from 11 March 2019 to 13 August 2023 as MO MBBS and MNHO1 respectively, and at Bhagyapur MPHC, situated at Bhagyapur village under Sorupathar BPHC in the district of Golaghat, Assam, with effect from 14th August 2023 to till date as MNHO1 for a period of 5 years. This is important. 5 years, 5 months, 30 days continuously and satisfactorily. So this is continuous service and satisfactory service, Lordship, for 5 years, 5 months and 30 days. That was certified by the Joint Director of Health Services as well as the Director of Health Services. So that was ignored, Lordship, while considering my application, Lordship. Whereas under the study leave rules of 1964, 5 years is required, and they have no objection with regard to that, Lordship. Rule 3 of the study leave rules, Lordship. That is applicable in my case.
That certificate, my lord, that is inclusive of the service rendered under NSM, not under government exclusively, my lord.
NHM is an instrumentality of the government itself,
my lord.
and for state health quota seats, this rule itself says that that period of service is to be counted, Lordship. Now, they have denied that, Lordship.
Okay. Heard Mr. MP Sharma, learned counsel for the petitioner, and Mr. D. Givara, learned standard counsel for the health department. Argument concluded, order reserved.
I just got a prayer from the Lordship now. If Lordship permit me, my Lord, can I make a prayer, my Lord?
Yes, yes.
There's one item number 40. This matter is fixed today for instruction, but the standing counsel for education department is newly appointed. Yes, first time he's appearing. He said he wants some time. Let it come upon next 20.
Item number 40.
48. 48, my Lord. For the first time he's appearing today for the standing council education department. For NC Hills, NC Hills Autonomous Council. 13/11, there is an order, my Lord.
Okay. Heard Mr. M. Nath, learned senior counsel assisted by Mr. Learned counsel for the petitioner, and also heard Mr.
R.R. Kosik.
R.R. Kosik, learned standing counsel for the
LC, additional standing
NC
council.
Hill Autonomous Council, Haflong,
For education department.
for education department. Mr. Kosik submits that he is newly appointed and he may be granted some time to file,
To obtain instruction. my Lord.
to obtain instruction, to obtain necessary instruction. Where is accordingly allowed, list the matter on
25th, my Lord.
25th. Okay.
If you apply, my Lord.
I have one small.
Yes.
There is a notification already, Lordship, wherein the registration for the first counseling is being conducted from today to 28th. So
Now, that interim order will continue till passing of the final order by this court.
that Lordship will clarify.
And your lordship will consider the or rejection order produced today, my lord, because in the affidavit, there are two rejection order. The issue is same.
Definitely,
Issue
definitely.
is same, my lord. So in the affidavit, we have annexed the rejection order for pursuing fellowship in Shankardev University. And today I have produced the rejection order rejecting the prayer for NOC, my lord.
Is in it.
That is dated 3/10/2020 today. Obliged, my lord.
But anyway, it is listed today. Can we not consider your pair today?
Lordship, in fact, my lord, I am appearing for the petitioner, my lord, and I am filing my objection, my lord, to their IA, my lord.
Acha.
So, in that way, my lord, I also require some time, my lord. By next week, my lord, I can file.
Next week, as agreed by learned advocates of both the parties, list the matter on. Bobby?
25th.
20, not 25th, but 26th. 29th.
29th will be too late. If
So many cases there.
there may be some confusion because the person petitioner is going to retire.
That doesn't
It is
matter.
an emergency matter. If the person retires before the something order is passed, then it may create some confusion in future. So matter will dispose, some effort may be made to dispose the matter earlier. So
Okay, 25th.
25th.
There is an interim order, my lord, in the writ petition, my lord. That may be correct.
Interim order passed earlier shall continue.
If you like.
Yes.
Timing item number 6.
May I please, your lordship, matter relates to non-payment of pensionary benefit and monthly pension, lordship. Petitioner before your lordship is the daughter of the Shahjudin, who was a LP school teacher, died in harness, lordship, in the year 2013. Thereafter, lordship, till date, pension was not paid. Earlier occasion, lordship, in this case, learned counsel for the education department, elementary education, was asked to obtain instruction.
Mr. Khatonia, are you for the respondent?
Malaka, I'm appearing for response, madam. It is now. It's just some trouble.
Have you received any instruction?
No, my lord.
Then,
No, my lord. But we'll fix it on next week, my lord.
heard Mr. L.R. Mazumdar, learned counsel for the petitioner, and Mr. Khatunier, learned standing counsel for the elementary
Elementary
education
education.
department. All the respondents?
All the rest, my lord.
For all the respondents, Mr. Khatunier submits that though High Order dated 21/8/2024 the standing council was directed to obtain, no, to receive instruction in the matter. The same has not been received and price for listening the matter next week. Here is allowed, list the matter on.
Online. 29th. Timing item 8.
Also, this matter pertains to provincialization of service number. This is the second writ petition with fresh cause of action. My lord. Fact is that, my lord, the petitioner is assistant teacher, social science in the Mathakata Banasaba ME Madrasa in the district of Dhubri, my lord. And during provincialization process, his post was dropped and he challenged the provincialization order of respondent number 7 and 8. My lord, the earlier order may find page 62, my lord.
What is the impugn order?
This court, my lord, earlier passed some order directing the petitioner to file
Oh, there's
appeal.
a order you have challenged in this petition.
Yes, my
At page number.
That is page number 35, my lord.
35.
35. It is the order passed against respondent number 7 and 38, my lord, page 38. This order was passed against the respondent number 8.
Yes.
Now, my lord, the case of the petitioner is that, my lord, he is a social science teacher and law provides social science subject as a compulsory subject, section 3111 of the 2017 Act. Now, my lord, on the pretext, my lord, of the provision of 2017, he challenged these two orders or provincialization order of respondent 7 and 8. My lord, this court has pleased to pass an order, my lord, that may find page 62. Lordship got it. And relevant direction, my lord, page 65, para 11, my lord, can you see? After hearing the learned counsels for the parties and considering the entire aspect of the matter, the petitioner is directed to prepare a statutory appeal before the Secretary, Department of School Elementary Education, Assam, under Section 14 of said Act, as amended for redressal of his grievances, forthwith along with a certified copy of this order and a copy of this writ petition, including annexes appended thereto, before the said authority, obtaining necessary acknowledgement from it in that regard. In the event of filing such appeal, the petitioner before the Secretary, Department of School Elementary Education, Assam, as directed above, the concerned appellate authority, after giving an opportunity of hearing to the petitioner, as well as the respondent number 7 and 9, Abdul Motin and Abdul Majid, respectively, and considering all the relevant documents and detailed reports as required for the purpose of provincialization under the said Act of Act 2017, under the said 2017 Act as amended, shall dispose of the appeal of the petitioner by expecting order within a period of 60 days from the date of receipt of certified copy of this order, intimating him as well as the respondent number 7 and 9 about the outcome of the said appeal. Thereafter, my lord, we have the petitioner filed an appeal, my lord, page 67. And he was asked to appear before, asked to appear for hearing, my lord. That is page 75. And accordingly, he appeared, my lord. It was dated 18/3/2024. Page 75, my lord. To Nurbahar Sheikh, my lord, the petitioner. Subject hearing scheduled on 22/03/2024 in connection with the order dated so-and-so in WPC number so-and-so. With reference to the subject cited above, I have the honor to inform you that a hearing date in connection with the order dated so-and-so in WPC number so-and-so, Nurbahar Sheikh versus State of Assam and 8 others is
No,
scheduled.
that's
by-
all right, but whether you have appeared before the
Lordship, I have
concerned
appeared.
person or not?
I have appeared. Thereapter, my lord, no result has been, my lord, communicated to me till date, my lord. Whereas the direction was of this court was to dispose of the appeal within 60 days from the date of receipt. The authority was supposed to dispose of the appeal within 60 days from 21/6/2023. I have filed the appeal on 21/6/2023, my lord. Now, the grievance of the petitioner is that the, my lord, appeal, which has not been disposed of yet, and nothing has been communicated, my lord. I have appeared before the authority at the, for the hearing, my lord. And hearing was conducted. Are other two respondents also appeared, my lord? So, my lord, let the direct, my lord, the authority be disposed of my appeal expeditiously, my lord.
Mr. Khatuniya?
Yes, madam. Otherwise, I have no objection to that prayer, madam. It's basically it's a case of contempt, madam, but since the order of
Time bar.
order of 2/12/2022, so now he has preferred the repetition. Since hearing has already been taken place, madam, so I have no objection, madam. Madam may direct the department to communicate the order if it is part.
We'll pass the order. The representation has to be disposed of within 1 month from the date of receipt of certified copies of the order.
Item for stay vacating. Item numbers 25 and 26.
But, in this case, my lord, item number 25I, I will not press, my lord, because this is a transfer matter of 2023, my lord. And due to effect of time, my lord, that petitioners, some of them will promoted and transferred to some other place. So, and item 26, they have challenged the notification regarding the power of the DC to transfer the ministerial staff. Let it be there, my lord, this item 26 and 25. The IA, my lord, I will not press.
This IA, you are not pressing this IA number 1003.
My lord.
Or Mr. Khan,
I-
learned counsel for the
In IA opposite party, Lordship. You read
for the
petition
opposite party.
in IA.
Mr. Z Pego, learned government advocate, representing government advocate for the applicant. For the applicant, and Mr. M Khan for the respondent opposite party. Mr. Pegu, learned government advocate, submits that this interlocutory application is preferred for vacation stroke modification stroke alteration of the order dated 3/8/2023 passed by this court in WPC number 44182023. And that he has the instruction not to press this matter and contended to close the same. In view of the submission of Mr. Pego, learned government advocate, this is. Yes, in 26.
Item 26. 26.
Actually, I think 26, the rule has already been issued. Like it will go in hearing of, because rule has already been issued in this case.
Heard Mr. M. Khan, learned counsel for the petitioner, and Mr. Pego, learned government advocate for the respondents. All the respondents?
No, madam. For the number 2 and 4.
12.
2 and 4.
2 and 4. Respondent number 2 and 4. And for rest of the respondents?
Department, secondary. 1, 3 and 5.
1, 3 and 5.
1, 3 and 5. Your good name, please? It is submitted at the bar that service has already been completed and the matter is ready for hearing. Affidavit in opposition file?
No.
Mr. Pego?
No, madam.
Then are you interested to file the affidavit in opposition?
Madam.
When?
This is challenging the role, my lord, notification, so it will take some time, my lord.
Mr. Pego, learned government advocate for the respondent number so and so submits that he may be granted 4 weeks time to file affidavit in opposition. Here is accordingly allowed. List the matter after 4 weeks.
Items for admission, item number 27.
My lord, in this case, two contradictory affidavit has come, my lord. That is one filed by respondent number 4 and another is by respondent number 2. So in view of that, my lord, honorable court, my lord, on 13/5, one observation was made, my lord. So in this case, my lord, the director has filed a very interesting affidavit, my lord, by which they are saying the withdrawing of the, my lord, PhD increment. That is due to, my lord, fault of the, my lord, principal. So, my lord, in that respect, the principal, my lord, have to respond in this case, my lord.
My lord, I am appearing for respondent number 4, my lord, principal, my lord. The copy of the affidavit filed by the, my lord, director has not been served upon me. They have given something which is contradictory to my affidavit. So that may be served upon me so that I can communicate to the principal and to know the appropriate, to bring the appropriate instructions, my lord.
Heard Mr. P. Mohanto, learned counsel for the petitioner. And also heard Mr.
Use Soikia.
U.J. Soikia. Learned standing counsel for, no, not
I'm
standing,
for
learned
respondent
counsel for the respondent number 5.
4.
4.
4, my principal.
Respondent number 4. The learned counsel
And
for the
who was
respondent number,
represented by, my lord? I am appearing for the higher education, but my lord, I am
Mr. Upamanya, learned standing counsel for the respondent number 1, 2 and 3. 1, 2 and 3. The learned counsel for the respondent number 4 submits that the petitioner may be directed to furnish a copy of the petition to him.
No, my lord, this-
No. Copy of the affidavit in opposition filed by the respondent.
Okay. Copy of the affidavit in opposition filed by respondent number
2.
Respondent number 2. Mr. Mohanto, no, who is for respondent number?
He is appearing.
Mr. Upamanya?
I will furnish.
Mr. Upamanya, learned counsel for the respondent number 2. undertakes to furnish a copy of the affidavit to the learned counsel for the respondent number 4 during the course of the day. So list the matter after.
My lord, on, is it possible on 5th of December, my lord?
5th of December.
Must be. And on that day, my lord, all instructions will be given.
Good. Okay, the learned counsel for the respondent number 4 will obtain necessary instruction in this regard and apprise this court on the.
Coming item number 10 for motion. May it please the Lord.
Yes.
Thank you. My lord, what had happened, the petitioner is presently working as in charge principal. Now, on 22/12/22, an order was passed by which the principal of Dayat Hailakandi was sought to be transferred in my place. Then, my lord, we challenged that order. Initially, Honorable Court stayed that order, and subsequently, that order was recalled. When that order was recalled on 21/1/23, we withdrew the writ petition. Thereafter, my lord, some AMSU members, all some minority students union members, they lodged their complaint against the petitioner before the ADC, Additional District Magistrate. My lord, the ADC is not my disciplinary authority, my lord. ADC, I do not know if there is anything wrong against me, they should advert to my appointing authority, my disciplinary authority. Now, apparently, my lord, the ADC caused some inquiry, and based on the report of the inquiry, a show cause notice was issued to me. I challenged that show cause notice in WPC number 4357 of 23, and kindly see that order, my lord, at page 79. And the operative portion is at page number 81.
No coercive action.
No coercive action. Now, in spite of that, my lord, a DP has been initiated against me. I have been placed under suspension, and everything is going on, my lord. My lord, matter is very simple. There was a set of allegation against me, that too to an authority who is not competent to take any action.
No, who is your disciplinary authority?
My director, my lord.
Director of Higher Education.
Director, yes. How can the ADC make an inquiry? Yes. In an administrative field, my lord, if there is something lapse and all, that's a different thing. The ADC will make inquiry, he will send it to the appropriate authority. That's a different issue. Now, based on the inquiry, ADC's report, my lord, action has been taken. Now, High Court says don't take any coercive action, meaning thereby don't proceed any further. Initially, show cause was issued. Thereafter, my lord, disciplinary proceeding has been initiated, inquiry officer appointed, I have been
Whether
suspended.
this writ petition was disposed of or not?
No, that's pending. Not even the returnable date has not even come now. Now, my lord, my only
then,
grievance at this stage is, my lord.
No, then the matter would have been agitated before that court.
Not necessarily, my lord. No, there's nothing
Whether
like
the
it.
separate writ petition is maintainable.
No, my lords. Yes, now because new cause of action has arisen. After the filing of that writ petition, after the order, this action has been taken. It's a separate cause of action. Now, my lord, my humble submission is very simple at this stage. Now, my lord, otherwise, I am due for selection as a regular principal. Now, let that selection not be stalled, my lord. Let them make the selection subject to outcome of this case. Normally, what happens, my lord? Whenever there is a DP, there will be a, my lord, seal cover procedure.
Seal cover procedure, yes.
Let that also be continued. Not that they will not consider my case. If they do not consider my case, I miss the bus. A serious prejudice will be caused to me. If they construe that there is a DP pending in me, very well. But they should not, my lord, not consider my case. They should let them consider in seal cover. That's the procedure, lordship.
No. Is there any indication that they will not consider your candidature order post of
No, I have
principal.
been suspended, my lord. I have also been suspended.
Hmm.
My lord, it's absolutely arbitrary, my lord. At the end of the day, some inquiry behind my lordship knows, if in that inquiry I was part, then also it's all one thing. I was not even a part of that inquiry. Behind my back, some inquiry has been made. Some complaint has been filed by somebody. Based on that, I am sought to be victimized.
No, a preliminary inquiry is permissible.
No, my lord, preliminary inquiry is permissible. But if I am not party to that preliminary inquiry cannot be used as evidence against me. That is the subtle position of law.
No, proceeding is yet to be started now.
No, they've started. They've started.
No, whether they use the report of preliminary inquiry or not.
My lord.
In the proceeding.
No, that inquiry of whatever the inquiry additional deputy commissioner has done, that is the basis for all the actions. I was not associated in that inquiry. I was not given any notice that there is a complaint against you. Please participate in this proceeding. We are going to inquire about it. Lordship knows if I am not part of it, then that finding cannot be used against me. If you want to, or additionally, my lord, a copy of the inquiry report done by the additional ADC should have been given to me. Nothing of this sort has been done. Let us not go to all these things, my lord. Some meaning lordships will give to the no coercive action. No coercive action means you will not precipitate any action that they have precipitated by suspending me, by appointing an inquiry officer, by appointing the Milord inspector of school as an in charge principal of this school. All these actions have been taken. Now, lordships will examine this. What I feel is, my lord, this proceeding should not come in the way of my consideration for the regular principle. They may keep it in seal cover, but they must consider it. That is my only prayer at this stage. And my lord, suspension, my lord, kindly see. How is it permissible when court says do not take any coercive measure? Lordship knows when court is in session of the matter, the administrative authorities are not supposed to make further inquiry, my lord. I am placing the judgment, dividend bench judgment of this honorable court. I can take. Para 15 of the judgment, my lord. That writ petition is pending. There is a restraint order. So this honorable court says, my lord, when this court is in session of the matter, on the same subject matter, normally they should not proceed, my lord. My lord, there is nobody is disputing the power of the authority to take action. But the action must be taken in accordance with law. That is the 226 is all about, my lord. We are concerned with the decision-making process. We are not concerned with the merits of the decision. If a manner is prescribed for taking a decision, you must take the action in that manner. No other manner is, recognized in law.
That Nazir Ahmed principle.
Nazir Ahmed.
Yes, Mr. Khatania.
Yes, my lord. My lord, kindly come to page 76, my lord. This is the notice given to the petitioner by the additional deputy commissioner when the preliminary inquiry was conducted, my lord. In view of the complaint received from AMSU, Hailakandi District Committee, an inquiry has been initiated against you by the Deputy Commissioner Hailakandi for corruption and embezzlement of government sanction fund. As such, you are here.
Under what authority he has started the disciplinary proceeding?
This is a completely preliminary inquiry. On the basis of the preliminary inquiry, my lord, now the government has initiated the departmental proceeding, my lord.
Now, can we see that order?
Page 82, my lord. This is the so-called notice issued by the government, my lord. On the basis of, my lord, can we come to page 83? 83, then my lord, 84, my lord, the list of documents. Inquiry report received from DC Hailakandi while letter number dated so and so. Report from director SCRT and complaint from so and so, wife of so and so. So these are the list of documents, my lord. So here, my lord, the report of the inquiry is in the list of documents. In fact, the petitioner was given the opportunity to inspect the documents, my lord, but he failed to inspect, my lord, and he sought for some further time. Page 88, my lord. Page 88. In inviting a reference to the subject matter, I have the honor to request you that due to flood situation and lack of communication, I find difficulties for inspection of documents with so-and-so in connection with Department of so-and-so, and so that 1 week time for coming normal situation of flood and communication. I therefore request you to kindly allow me to extend of date for at least 1 week. So this is not the case, my lord. He has not been given the opportunity during the preliminary inquiry. He was called for the inquiry, my lord. And on the basis of that preliminary inquiry, my lord, now departmental proceeding is initiated by giving the so-called notice, my lord. Please.
No, while the court has directed to not to take any coercive action,
That
how
as
can you
regards
proceed?
deputy inquiry conducted by the deputy commissioner, my lord. It's not about the disciplinary proceeding, my lord. We can very well initiate the disciplinary proceeding, my lord. There's no bar, my lord. And it's not a coercive action, my lord. To initiate a disciplinary proceeding, it's not a coercive action, my lord. He will be given the full opportunity of heard, my lord. Thereafter, inquiry hearing will be conducted. And as regards
regarding the submission of Mr. Chaudhary that he may be allowed to participate in the selection
that, in fact,
process.
my lord, I have seen the prayer made in the writ petition, my lord. In fact, in the interim also, that prayer is not there, my lord.
Well, that's a development which has come to our notice very after filing of this petition.
In that file, my lord, my learned friend, senior friend, may file an
File
IA, my lord, IA, sorry.
I want to reply to my learned friend. My lord, will kindly come to page 82. The fourth subpara. Whereas, as per the inquiry conducted by Tridib Roy, ACS Additional District Commissioner of Hailakandi, has reported that so-and-so, so-and-so, so-and-so. My only submission is, my lord, can this be germane for a disciplinary proceeding? End of the day, the satisfaction has to be of the disciplinary authority. My appointing authority satisfaction. My lord, AMSU is writing a letter to ADC. ADC makes some complaint. How can that be a basis, my lord? End of the day, my lord, there is something called semblance. What is it, my lord? My only case is I'm challenging the decision-making process. My learned friend is absolutely correct when he says there is no bar to initiate a disciplinary proceeding. Correct. But disciplinary, what is the basis of the disciplinary proceeding? The report of the ACS, that ADC. Who is ADC, my lord? Is he not a stranger to the entire scheme of things? At the end of the day, then what is the meaning of procedural safeguards? Why it is said, my lord, what is the meaning of procedural safeguard? If this is how things are to be construed, with all respect, my lord, this is one aspect. Secondly, on the inquiry of the ADC, there is an order of this Honorable Court, no coercive action. Can they proceed? Are they not showing disrespect to the authority of this Honorable Court, my lord? Now, this ADC's report cannot form the basis for any action. That is what High Court prima facie said. If High Court dismisses that petition, that's a different issue. But on the date when, my lord, I was placed under suspension, on the date when the show cause notice was issued, that order was holding the field.
No, that's all right. That matter will be adjudicated later on. But now you tell me, without an affidavit, can we issue direction?
No, my lord, writ petition, my lord, writ petition, my lord, it's not like a civil proceeding where everything must be supported. Yes, the foundational facts has to be there. Now we are saying it's a question of protecting, my lord, pendency of this case. Because this matter cannot be decided today because they'll have to file their affidavit. All that I am saying, my lord, in the meantime, if they proceed, then they will put it in seal cover because they have initiated DP. Only that much, my lord. I am not saying to declare my thing. Let them file their affidavit. Let them, if they initiate, then they will, my lord, consider in seal cover. So that ultimately, if I succeed, I do not suffer any prejudice. Tomorrow, my lord, if I succeed in the writ petition and they do not consider my case, then I will be seriously prejudiced. And on the contrary, if I do not succeed, then Lordship will vacate that order. That seal cover will not be open.
So balancing the equities, my lord,
Mm.
I think irreparable loss would be caused to me if the order is not granted. If the order is granted, then it can be balanced. If your lordship finds no, there is no merit in the writ petition, then lordship will say, don't open the seal cover.
No, no.
That's the only thing.
No, no, to substantiate your claim that you may not be considered for being selected to the post of principal. So, is there any material in the?
No, my lord,
before
what
the
I'm
court
saying
today?
is, I found in so many cases where DP has been initiated, they do not consider. Their own circulars are there, my lord. Lordship knows in Janaki Raman's case, Supreme Court said, when it can be said a criminal case or a DP is pending. Merely because an FIR is lost, it doesn't mean a criminal case is pending. Merely because a preliminary inquiry is pending, it does not mean a disciplinary proceeding is pending. So Supreme Court has clarified, only when charge memo is filed, in either case, criminal or civil, then it can be said either a criminal case or DP is pending. Now they have initiated DP against me, my lord. So there is no dispute that there is a pending, DP is pending. So they definitely they will not consider my case. But I apprehend, my lord, that they will not put my case in seal cover. That's the only protection I am seeking, my lord. By putting in seal cover, it's not that they will be giving me promotion. That's the only prayer, my lord. If your lordship wants, I can file an additional affidavit also. There is no difficulty, but then I don't think any prejudice would be caused to anybody. That is the only thing I'm saying at this stage. And further prayers, lordship will consider after they file the affidavit.
Okay, Mr. Khatuniar, when you are going to file your affidavit?
Well, at least 4 weeks, madam.
4 weeks. Okay. We permit you to appear in the.
Yes, they'll put it in seal cover.
We'll pass the order.
My lord, deeply up.
Big item 24.
Who is for the caveator in this item number 10? Ever?
I was appointed as to hold the office as principal in charge only for a limited period. That is after his suspension, my lord. That is from 8/10 to 18/10. Thereafter, Inspector Vishnu was allowed to hold the charge of Inspector Vishnu.
As of now, my lord, our claim is.
Now the Inspector Vishnu has been holding the charge of Inspector in charge principal of that particular diet.
Okay. Caveator we are. No, whether this caveator deserves? No, not deserves.
That may be decided.
Okay. Caveator we have, caveat distance deserves. Okay. Next item.
Item 24. Respondent number 2, I am appearing in this case.
Okay.
That
That's
may
a
be
big away. Learned counsel for learned standing counsel for
SCRT.
SCRT.
yes.
Okay.
Paid vigilance. My lord, the issue in this case is regarding, my lord, the doctorate of PhD degree of the petitioner. What had happened, there was earlier, there was a case. On last occasion, on last occasion, other side said that my petition contains 74 pages. How come you are having so and so page?
Lordship may be taken up tomorrow, because I have brought them same name, Lordship, the another case. Where already motion in interim order has been passed in that case.
That is our court. It's a subsequent court.
4307, name is same, Lordship, so some
Maybe same.
Lordship.
Maybe name may be
Yes,
same.
Lordship, some confusion was there in the.
Name is same.
Some confusion was there in taking out the file, so
He wants tomorrow, my lord.
Tomorrow. Okay. But Mr. Ken Sodri, learned senior counsel, assisted by Mr. Swenson, learned counsel for the petitioner, and Mr. K. R. Towelder, learned standing counsel for respondent number.
Higher Education Department.
Mr. Towelder, price for listing the matter tomorrow. Fair allowed.
All right.
Item numbers 28 to 32.
Lordship, in this matter, we have filed an, Lordship, the affidavit has been sent to the department, your Lordship, but there are some corrections to be made in the affidavit, your Lordship. It's because there's a series of cases related, your lordship. So some corrections need to be made, your lordship.
Last one, may kindly be produced.
So find it, time maybe.
22 madam, my lord, some of the petitioner are going to be retired, my lord, without.
When?
My lord, 57, 58 years, my lord, they have not, their service has not been provincialized. My lord. Last opportunity may be granted, I am not repeating, my lord. Last order may kindly produce, my lord, in item number 28, my lord.
Item number?
Last item of series, my lord, Mukul Sharma, my lord. 2910.
So madam, we are granting only 1 week time to you.
Yes, your lordship.
Besides, we will fix the date.
My
Third, Mr. Zeloskar, learned counsel for the petitioner, and Ms. H. Dharampi, learned standing counsel for the secondary education department. Ms. Dharampi submits that
Correction is to be
affidavit
made, your
has
lordship.
already been prepared and the same was sent to the department for correction.
Yes, your lordship.
And see, price for granting 1 week time, here is accordingly allowed. This is the matter. On.
29.
29.
Apply.
Item numbers 33, 34, and 35.
Same.
Here, your lordship. If your lordship rules, the order is at 29/1/2024, your lordship. 29/1/2024. Department.
Order dated
29/1/2024.
Yes. Affidavit not filed till today.
No, I need 10 days time, my lord.
Otherwise, you are allowed to participate in the selection process. And our results are directed to be kept in seal cover, your lordship, by this order. Selection process has not been completed yet, your lordship. If they can come up with the affidavit within 10 days, your lordship.
Okay, third, Mr. Borthakur, learned counsel for the petitioner, and Mr.
PK Bora, my lord.
PK
Bora, my lord.
PK Bora, learned standing counsel for
Elementary Education Department.
Elementary Education Department. Mr. Bora submits that he may be granted 10 days time to file affidavit.
As per order dated 29.
Dated 29/1/2024. There is allowed. But it is made clear that no further time will be granted to Mr. Bora to file counter affidavit.
Deeply obliged.
Item number 36.
May I please? The petitioners before your lordship are the non-teaching staff of Adarsha Vidyalaya, my lord. What happened, my lord? They are appointed on contractual basis, both the teaching and non-teaching staff, initially for 11 months, and thereafter it is continued till date, my lord. And the teaching staff and the non-teaching staff, their appointment are made in the same procedure, my lord. But the teaching staff is given the ROP based salary as per government notification, which is not given to the petitioner. Thereafter, the matter is agitated, and accordingly, a cabinet decision was taken, my lord. May I take your lordship to the decision, page 82, my lord. Lordship got it.
Yes.
In pursuance of the cabinet decision taken in the meeting of the Council of Ministers held on 24/9/2021 in the conference room of State Guest House, Koinadhara, Khanapara, and for effective administrative control and monitoring of Adarsha Vidyalaya functioning as on date under Samagra Shiksha Assam, the government of Assam, after careful consideration of all aspects, is pleased to notify constitution of Adarsha Vidyalaya Sangathan, Assam for operationalization and management of Adarsha Vidyalaya, and the said Sangathan will act as an autonomous body under Secondary Education Department, Government of Assam. My lord, thereafter skip 2 paragraphs. Next, my lord. Necessary budget provision will also be made in the state budget to meet the recurring and non-recurring expenditure for operationalization of 46 Adarsha Vidyalayas may be extended by Government of Assam as a future policy decision. This includes payment of salary and honorarium for the officials of Adarsha Vidyalaya Sangathan, payment of salaries to the teaching and non-teaching staff of Adarsha Vidyalaya as per ROP, except daily wage workers. My lord, the petitioners are not the daily wage workers. Thereafter, my lord, for a moment, kindly come to page 87, my lord. As per the said decision, the teaching staff, graduate teacher and principal, they are allowed the ROP based salary. Now, my lord, kindly come to next page. Same date order, 31/2023. In pursuance of the decision taken in the review meeting of Adarsha Vidyalaya Sangathan, Assam, held on 15 October 2022, chaired by the Honorable Chief Minister of Assam, Adarsha Vidyalaya Sangathan is pleased to notify that all existing incumbents drawing fixed pay in the functional Adarsha Vidyalaya of Assam shall henceforth be entitled for 3% of annual increment only. We are not given the benefit of ROP based salary. So this is my grievance, that I am deprived from the benefit of the decision, cabinet decision. This is my simple question.
Mr. Katonia?
Yes, madam. But though initially, my lord, benefit was given to all the teaching and non-teaching staff, my lord. Subsequently, my lord, it has been revised, my lord. There was a review meeting, my lord. I have annexed the minutes of the review meeting at page 94. I filed an additional affidavit, my lord, on 4th of March. Page 94, my lord.
94 is an affidavit.
My lord.
It is the affidavit filed by respondent number 5, my lord. On 4/3/2024 month.
Yes, well, page 94.
$94 or 100? Annexure A?
Annexure A.
Yes. This page number 100.
It's the minutes of the review meeting of Adarsha Vidyalaya Sangathan, my lord.
Yes.
Held on 15/10/2022. Yes, madam. In my
Right.
Here, my lord, the resolution number 4. The benefits of ROP shall not be applicable for teaching and non-teaching staff of Adarsha Vidyalaya who are engaged on fixed pay basis as their entry point initial engagement procedure differs from others. However, they shall be entitled for 3% annual increment. So this is the decision taken subsequent to the notification, my lord, by the chairmanship of the Honorable CM, my lord. And since they have been appointed on fixed pay basis, so their entry point and initial engagement procedure is different from others, my lord. So that is why they have been given the benefit of 3% annual increment instead of, my lord, scale of pay, my lord.
So your grievance is 3% only, or scale of pay?
Scale of payment.
Scale of pay.
Because others who have been appointed through a regular selection process, they have been given the benefit of scale of pay, my lord, pursuant to this notification. Thereafter, a review meeting was conducted In that review meeting, a decision was taken. Those who have been given appointment on fixed pay basis, they will be given the benefit of 3% annual increment instead of scale of pay, my lord.
My lord, it is not correct
No,
to
this
say.
annexure 15, page number 88 relates to only 3% increment. Right?
My lord. They are given only 3% increment, but not given as the
Scale of pay.
My lord, their say is that the entry point and initial appointment was separate from the petitioner, teaching and non-teaching staff. It is not correct, my lord. Both the teaching and non-teaching staff are appointed initially on contractual basis for 11 months, and it is extended from time to time. So there is no difference between the teaching and non-teaching staff. And furthermore, my lord, a cabinet decision whether can be reviewed by the chief minister, my lord, in a meeting of Adarsha Vidyalaya. Well, kindly see the annexure A, meeting of the review meeting of Adarsha Vidyalaya Sangathon. This is the meeting of the Sangathon only. But the decision is taken by the cabinet, my lord. Whether a cabinet decision can be altered by a Sangathon, my lord. My limited understanding says that as per Article 164, it cannot be done.
Mr. Katonia?
Yes, my lord.
And I have responded to their affidavit, my lord. Will you kindly come to my affidavit, additional affidavit? I have annexed the appointment orders of the principal, some orders. Here it is clearly mentioned the engagement is made purely on contractual basis for 11 months. All the appointments. I have annexed as many as 3 engagement orders.
Have you challenged this subsequent review?
No, this is not
Meeting
on
minutes?
challenge.
No, my lord.
No.
That decision is not on the challenge, my lord.
No, the question is, can the cabinet decision be reviewed by the CM? Cabinet decision may be reviewed by the cabinet only, perhaps.
Yes, my lord.
Maybe well, subsequently that may be placed before the cabinet, my lord. That I'm not sure.
Then you obtain instruction.
Yes, my lord.
We'll release the matter tomorrow,
Not tomorrow, my lord. Tomorrow I may not be able to. Day after tomorrow, my lord.
day after tomorrow.
Yes, my lord.
Okay. Yes. Heard Mr. Alim, learned
Yes,
counsel
Alim.
for the
Yes, Alim.
S. Alim, learned counsel for the petitioner, and also heard Mr. Katonia, learned standing counsel for the education department. On the prayer being made by Mr. Katonia, rest shall list the matter day after tomorrow so as to enable him to obtain necessary instruction. Prayer is accordingly allowed, list the matter day after tomorrow.
Obliged.
Item 37.
I am obliged, my lord.
Get Nicholas. My lord, the matter regarding pension of the petitioner, my lord, earlier occasion, your lordship was pleased to ask the government side, my lord, to produce, my lord, service book for the petitioner, my lord. Here in this case, my lord, as per my instruction, my lord, they themselves, my lord, under their seal and signature, wrongly, my lord, entered my my lord, date of birth in the service scope
Hmm.
as my lord, 1/1/1965, my lord. Therefore, my lord, my lord, as per their date of birth, I have to retire, my lord, in the year 2025, my lord, even. But actually, my lord, I ought to have been, my lord, given retirement in the year 2018, my lord.
Hmm.
Nevertheless, my lord, in the meantime, my lord, I had been overstayed in service 3 years, my lord. Subsequently, as per verbal instruction of the block development officer, I was, my lord, retired. And till date, my lord, pensionary benefit is not finalized.
Yes, who is for respondent number 1, 2, 3, 5, 6, and 7? Okay, okay. Secondary education, secondary or elementary?
Elementary one.
Elementary education.
Otherwise, my lord, this kind of, my lord, issue is already settled by this honorable court as well as honorable Supreme Court also, my lord. And I have also annexed some judgment in this writ petition also, my lord, for ready reference, my lord. Yes, under this situation, my lord, this honorable court, my lord, did not allow, my lord, recovery, my lord. Because, my lord, it was found, my lord, that if, my lord, petitioner is not involved in fraud or misrepresentation in overstay, my lord, then, my lord, recovery.
But the problem is that you are aware of your date of retirement.
No, my lord, cannot be, because, my lord, when he joined, my lord, in service, it was, my lord, 58 years. Then, my lord, without any, my lord, notice to petitioner, it was made 59, then it was 60, my lord. Obviously, my lord, this metric pass, my lord, LP school teacher, he cannot say, my lord, and it is not in the advertisement or appointment letter or in the entire service period. Never, my lord, it was communicated to him his date of retirement.
Now,
And,
what
my lord,
is your
and this issue was
no,
also
Mr. Barmuya? What is your prayer in this petition?
prayer, my lord, page 16, my lord. To release
Release
person-
your pensionary benefits.
Yes, my lord. B, my lord, not to recover, my lord. And lordship, it was also, my lord, held that, my lord, in any case, my lord, they are duty bound as per rule, my lord, to issue
notice.
notice, my lord, retirement notice, my lord.
So no notice was served to you.
No, no, till date, no notice, my lord.
Where is the judgment that is
My lord, I have annexed one judgment. It is in the respect of his colleague, my lord, petitioner, page 71, my lord. Page 71, WPC 1870, 2023, my lord. My lord, relevant portion, page, my lord, lordship kindly will look page 83, paragraph 24, my lord. 83, paragraph 24. Considering the fact that there was no allegation of misrepresentation or fraud which could be attributed to the respondent, and considering the fact.
No, that was the decision of Supreme Court,
Yes,
not the finding of the court.
Paragraph 26, my lord, regarding notice, my lord. In this page 24, 84, my lord, this regarding notice, it is duty of the state to put employee on notice about his date of retirement, and not having done so, the applicant was not entitled to recover the excess amount paid to the respondent, my lord. And in this case, my lord, it was provided, my lord, page, direction was given, page 88, my lord. under paragraph 20. Consequently, this code therefore dispose of both the writ petition with the following observation and direction. The communication dated so in this case, my lord, the recovery notice was issued. But in this case, my lord, even recovery notice is also yet not, my lord, issued, my lord. The communication dated
No,
so
whether you have received any notice for recovery.
no, my lord, there, my lord, whispering, my lord, that, my lord, recovery will be done, my lord,
But you have not received any notice.
not, no notice, my lord. Only, my lord, for the sake.
They may not recover it from your pensionary benefit
Definitely, my
also.
lord, definitely, my lord, they are, my lord, whispering, my lord, for recovery.
Whispering before whom?
Applicant. Therefore, my lord, yet they have not, my lord, finalized, my lord. And lordship, I have submitted another APDP.
Mr. Khatuniar, what is the stand of the
I have
department?
received instruction from the Deputy Inspector of Schools, my lord. As per his instruction, my lord, the petitioner has kept his service book in his own custody, my lord. In spite of repeated requests, my lord, he did not submit, my lord. Finally, he submitted it, my lord. And thereafter, my lord, came to the notice of the Inspector of Schools that his date of birth, actual date of birth is 1/1/1958. And in the service book, it was recorded as 1/1/1965, my lord. He produced a HSLC's pass certificate on 29/12/2004, issued by the SEBA on 28/11/2021, my lord.
So have you filed affidavit?
No, my lord, we have received the instruction. In fact, we have received it on month of May, my lord. Till date, we have not filed the affidavit. So, my lord, maybe, my lord, due to
You filed the affidavit?
there is some gap in our part, my lord. So, my lord, may give us 1 week time, my lord. Since I have received the instruction, I will file it, my lord.
Mr. Borbia, let him file affidavit. We'll dispose of the petition thereafter.
In the service book, my lord, admittedly, my lord, date of birth, they have under their.
No,
It was in his custody, my
No,
lord.
like, that cannot be, my lord. This is a, my lord, completely, my lord, wrong submission. One, my lord,
Let
LP school
him-
teacher.
I'll file the affidavit, let him deny it, my lord.
One LP school teacher, my lord, cannot, my lord, hold service.
One
book. It
LP
always-
school teacher will do several things, my lord.
Okay, I heard Mr. M. Borbia, learned counsel for the petitioner. And Mr. Khatuniar for the state for the respondents, standing counsel for the respondents. Mr. Khatuniar submits that he has received instruction, but he may be granted 1 week time to file affidavit. Here is allowed, list the matter on. We'll fix it at.
Yes,
Coming when?
On 29th.
20 on first of December, my lord.
1st of December, 1st of December is Sunday.
Oh, sorry, this is a 2025. Yes, my lord.
1 week time, or why not on 29th?
29th, my lord. Okay, my lord, 29th.
29th.
Item 38, July 1.
May please, there is IA, your lordship, 3433. The limited period, page 8, your lordship, there, the correcting the address of the respondent 7. The requisition we have mentioned is resident address, that means a assistant teacher of the school. And after service of notice, did not appear before the court. That's a on-out of supposed to direct that her personal appearance, but the different council said that it is difficult for us without official address, therefore I have asked to correct the official address. Now I has corrected, I filed for correcting as address, your lordship, as our official address, your lordship, school address. It is the pair. That is relates to pensionary benefits. He is
Heard
receiving.
Mr. S. Islam, learned counsel for the applicant. Mr. Khatuniar, you are here?
Yes, my lord.
And Mr. Khatuniar, learned standing counsel for the Respondent opposite party number.
I'm appealing for 8 and 9, my lord.
Respondent number 8 and 9. And Mr. Upamunya,
Lordship, I am for respondent number 1, 4, 1 and 4, Lordship.
1 and 4.
For respondent number 2, Lordship.
And Mr. Chakravarti for respondent number 2. This interlocutory application is prepared by the applicant for allowing to correct the address of the respondent number 7. In the cause title of the writ petition number so and so so and so. Any objection, Mr.
No, ma'am.
Adonia? Having heard the submission of learned advocates of both the parties, this interlocutory application stands allowed. The applicant is allowed to correct the address of the respondent number 7 in the cause title of the WPC number so and so. Amended cause title shall be filed within a period of 1 week from today.
Fix another next week.
No, today only this IA is listed.
Okay. Admission. It is admission. There is urgency is the case in pensionary benefit sharing. Mother only that mother claiming the share of pension benefit. And
No, all right, you file the amended cause title
by tomorrow I'll file.
tomorrow.
By tomorrow.
Then rest will list the matter
Next week, Your Lordship.
next week. Itu to নহব itu to list হোৱা নাই okay
Next week.
Item 39.
In this case, my petitioner praying on area salary.
Some 1 week time may be granted, Lordship. Area salary, Lordship.
you receive instruction.
No, instruction, kindly 1 week time for to the status loss.
Kindly say order dated 2/8/23 and subsequent orders.
Area payment.
Order number
Order dated 2/8/2023 and subsequent orders. And times.
It's a long running loss. So private salary, but area.
so more than a 1
Yes.
year elapsed.
That's true, Lordship. That's true, Lordship. That's for 1 week time.
You pay some cost then.
No, Lordship, 1 week. 1 week, Lordship. I'll ensure, Lordship. That's 1 week.
Heard, Mr.
As we are, Lordship.
K Kolita.
K. Kolita, learned counsel for the petition. And Mr. Bhuya, learned standing counsel for
I have
the
it, Lordship. 1 week.
respondent. Mr. Bhuya submits that he may be granted only 1 week time to file the affidavit in opposition. Fair is accordingly allowed for the last time. In the event of failing to file affidavit on next date, the court will consider imposing of cost.
On next Monday. Next Monday.
29.
Lord.
Item
29th,
29, my lord.
41.
Friday.
Yes, my lord. 20.
41.
If the covered matter and last several occasions, they have sought time to file affidavit, Lordship. Till then, no affidavit has been filed, Lordship.
Under here, I need some time to tell you, 2 weeks time. Last occasion, my lord, finance or finance department was included, but both.
So you have filed amended cost title.
No, Lordship, already as per direction of this honorable court, Lordship, finance department has met the respondent number 5, Lordship. As per direction of this honorable court, by order dated 30/10/2024, Lordship. So here finance has already been made a party, Lordship. But the education department on last 4 to 5 occasions, they sought time to file affidavit, but till date has not filed the affidavit, Lordship. Otherwise, it is a covered matter, Lordship.
Mr. Pego?
Hello. Hello, pending ground, 2 weeks time. to file.
5 times, Lordship, they have sought. 5 occasions, they have sought time, Lordship. Last
Or
occasion
Mr. P. Bordolo, learned counsel for the petitioner, and Mr. Z. Pego, learned standing counsel for the respondent number
1 to 4. 1 to 4.
1 to 4. Mr. Pegu submits that he may be granted 1 week time to file
Hello,
affidavit.
2 weeks time. 2 weeks time.
2 weeks time to file affidavit in opposition. Here is accordingly allowed. It is made clear that no further time will be granted to file affidavit in opposition. Leaves the matter on Kobe. Fix a date.
On 13th December.
13 December.
Firstly, finance is not so reflected now.
Pardon?
In the costly, finance department is not reflected. Only
Mr. Pego has pointed out that the finance department has not been reflected in the house list. Rest is I'll do the needful in this regard.
obliged.
Lordship, can it be on 8 December, Lordship? 8 December.
December.
8 December.
December Sunday.
Sunday.
December.
9 December.
9
Oblige you,
9 December.
Oblige you, Lordship.
42.
25.
May please, Lordship, the same situation, my last 2 occasions, they took time for filing affidavit.
Lordship, here, I have received instruction, Lordship, here. I will be allowed 2 weeks time to file affidavit. Otherwise, also, this is the 3rd round of litigation. In the initial first round of litigation, the service of the petitioner was regularized in August 2005. Thereafter, they challenged the applicability of new pension. Subsequently, that old pension was allowed by the Honorable Court, and accordingly, they were covered under old pension. Again, in the 2nd round of litigation, they challenged the for the arrears salary for the service period which was not regularized. And in terms of this Honorable Court's order, a speaking order was passed. Now this speaking order has been challenged, Lordship. So I will be allowed 2 weeks time. We have received instruction, Lordship. We are going to file our affidavit.
Heard Mr. Enhock, learned counsel for the petitioner, and also heard Mr. Sharma, learned standing counsel for the elementary education department. Mr. Sharma submits that he has received the instruction, but he may be granted 2 weeks time to file the affidavit in opposition. Where is allowed for the last time. List the matter on
13th December.
13 December.
Oblige. Item 43. Yes, please. Earlier, several occasions, Lordship, if you Lordship kindly peruse the order dated 17/5/2024, 7/6/2024, 19/7/2024. All this time, Lordship, they are taking time for filing affidavit. No affidavit has been filed, Lordship. Regarding Lordship matter is relating to pay protection, Lordship.
Yes, if you are not interested to file affidavit, then we will proceed to hear the matter.
Lordship will be,
When?
instructions are awaited, your Lordship.
When?
Lordship, 2 weeks, Lordship. Will be filing her. Because we have not received the instructions yet.
Oh, how many 2 weeks elapsed?
Yes.
Hmm?
As a last chance, Lordship may be given with the fixed date.
Lordship.
Heard Mr. M. Khan, learned counsel for the petitioner. And also heard Madam Musahari, learned standing counsel for the
Secondary education.
secondary education department.
1, 2, and 3, your Lordship.
1, 2, and 3. And Mr. Bhuya for respondent number
0.5.
4 and 5.
Higher education.
Have you filed your affidavit?
No.
No.
Only 5 years.
The learned standing counsel for the respondent submits that they may be granted 2 weeks time to file counter affidavit. Hearing accordingly allowed. Lays the matter on.
On 13th December.
It is made clear that no further time will be granted to file affidavit in opposition.
44.
Lordship, this is non-payment of salary, Lordship. Salary from March 2015, this petition is not getting salary, Lordship. If you, Lordship, kindly peruse last order dated 4/11/24. They said that they have received the instruction, it is sent for vetting, Lordship. But more than 1 week has been gone, but no affidavit is coming out, Lordship. So this is the fact, Lordship. For last 7 months, there is no affidavit. Earlier occasion, different occasion, they took time. Now, Lordship, the petition is still serving. They are neither said that her appointment is illegal or whatever, Lordship, and service is not terminated. So on that count, Lordship, the petitioner is entitled to for the salary, Lordship, which is served, Lordship. And she was appointed as stipend teachers as the High Court's order there, Lordship. I have enclosed, Lordship.
Who is for respondent number 1 and 3?
In this, Lordship, earlier I took time for up-to-date instruction, my lord. In this case, my lord, I have received the instruction, my lord, on 16/11/2024. My lord, a hearing conducted for the petitioner, and my lord, the petitioner which is relied, then the petitioner Phanugoy, and then he is another Phanugoy, my lord. That instruction, my lord, I have received, my lord, and the hearing also conducted, and she also deposited her statement, my lord, the petitioner, my lord. So, Lordship may allow me some time so that I can produce an affidavit on this
Last occasion, my friend submitted, it is sent for vetting, Lordship.
Sent for vetting for, and I pray for up-to-date instruction, my lord.
That is
Also be reflected in the order, my lord. And
Hmm.
accordingly, I have received the instruction, my lord. And on 16/11/2024, my lord, hearing was conducted, my lord, and the petitioner is দুটা ভানুগৈ মানে এওঁ যিটো কৈছে সেইটো ভানুগৈ বেলেগ সেইটো বেলেগ
So when you are going to file the affidavit?
Lordship may fix a date, my lord. I pray for 1 week, my lord. So Lordship, because I
Lordship, so that it comes now, Lordship. And
2
this week, so that this time they can file, Lordship.
So you are sure that in 1 week he will not be able to
Maybe,
file the
Lordship,
affidavit?
earlier occasion.
up-to-date instruction, my lord.
That's
16/11, my lord, hearing
Okay,
conducted.
heard Mr. S.U. Ahmed, learned counsel for the petitioner, and Mr. B. Talukdar, standing counsel for the
Elementary
respondent
education, my
number
lord.
1, 2, 3, and Mr. Medhi for the respondent number 5.
But we
Five.
have no rule, madam. Regarding arrears, salary and arrears, AG has no role.
Yes, yes.
Unnecessary made party, madam.
Okay. Okay. On the Mr.
I got 5.
Talukdar, learned standing counsel for the respondent number 1, 2, 3, submits that he has received instruction, but he may be granted 2 weeks time, 1 week time to file his affidavit in opposition. Where is allowed for the last time. List the matter on
On 4th December.
4th of December.
My name will also record this.
Item 45.
In this case, also, I also pray for some time, my lord. I have received the instruction, my lord.
Last occasion, they have submitted, the instruction has already been received.
Last occasion, I have-
25/9 order.
Lordship may fix it on Friday, my lord. In the meantime, tomorrow I will file.
No, why you could not file the affidavit?
Last occasion,
Hmm?
today morning I have.
The
received-
order was passed on 25/9/2024.
Yes, ma'am.
Your lordship's order.
So, if today morning you have received the instruction, then your submission on 25/9/2024 was false.
Maybe, my lord,
Hmm?
that instruction was not sufficient, my lord, for, my lord.
Not sufficient.
My lord. So, lordship may fix it on Monday, my lord, or Tuesday,
No,
my lord.
fixing is no problem.
Yes.
Problem is with you.
I will file, my lord. I will ensure, my lord.
No, why you have misleading the court on the 25/9/2024 that you have received instruction? Hmm?
I was not in,
Hmm?
I was not. Right.
Should we reflect it in the order? That on the other day you have make some other submission, today you have make some other submission, there is no correlation. Hmm? Okay, heard Mr. R. Islam, learned counsel for the petitioner, and Mr. Talukdar, learned standing counsel for the respondent number 124. Mr. Talukdar submits that he may be granted 1 week time to file counter affidavit. Where is allowed, list the matter on Friday. In the event of failing to file affidavit on that day, the court will consider imposing cost.
From 22nd December. Item number 46.
The 2nd November.
Oh, sorry, 22nd November.
The private respondent number 3 has filed an affidavit in opposition. Lordship may kindly grant me just 10 days time to file a reply, affidavit in reply.
Heard Ms. Borgomai, learned counsel for the petitioner, and Mr.
I'm for the respondent number 3. My lord, short date may be given. My lord,
Your good name, please.
Yes, Ali Lordship.
S. Ali, learned counsel for the respondent number 3, and you?
P. Sharma, Lordship, for APSC, Lordship.
APSC is respondent number?
Lordship, newly included, Lordship.
Respondent number 4.
Respondent number 4.
Lordship,
Ms.
here
Borgomai
address-
submits that the respondent number 3 has submitted affidavit in opposition, and she may be granted 1 week time. 1 week?
10 days, Lordship.
10 days time to file a reply to the aforesaid affidavit. Where is allowed. Rescission is the matter on
4th December.
May please, Lordship. Lordship, name of standing council APSC be reflected in the cause list, Lordship.
Okay. It is provided that rescission shall reflect the name of standing counsel for the respondent number 4 in the cause list.
47.
Much of.
Yeah, please, Lordship. Your Lordship may kindly, look to page number, Lordship, 62. Only, Lordship, regarding your provincialization service, everything has been done by the state selection committee has done it, and government has considered. And now the matter is pending for joint committee. Page 62, Lordship. Just, Lordship, may I-
It is pending for?
in the last, in view of, Lordship, your Lordship may kindly take. the-
In view of?
In view of the above, proposal received from DASM is forwarded herewith for consideration of the joint committee. Now the matter is remained pending the joint committee. Earlier, Lordship, several occasion, Lordship, instruction was sought for. Till date, neither instruction nor any affidavit has been filed. On the other hand, Lordship, only 4 years time is remained for the petitioner to go on retirement. Now he's 56 years. Regarding provincial.
Who is for respondents?
It's 60 detailed proposal. Lordship.
So nobody appearing for the respondents? Mr. Talukdar,
My lord.
are you appearing for the respondents?
For elementary education.
Hmm?
Section 14 of the report.
That has already been considered. It's the second round of litigation loss. Earlier round matter remanded to the state scrutiny committee. State scrutiny committee has recommended. It went to the government. Government has considered. After that, only lordship matter forwarded for joint committee. In fact, lordship, as per provision of Provincialization Act, there is no provision for joint committee. They are unnecessarily keeping the matter pending. Only state scrutiny committee, then government. That is the provision of law, lordship. There is no provision for joint committee itself. Even that lordship, if they have constituted the joint committee, they should consider it.
What to do, Mr. Talukdar?
Also, my disorder with
How?
Or Lordship may fix it on Friday, my lord. In the meantime, I will take instruction whether there is a joint committee or not, my lord.
Already forwarded committees there as per the.
No, whether there is a provision in the Act for constitution of joint committee?
No, my lord.
No. Let this secretary remain present before the court on Friday. Mr. Talukdar?
My lord.
If there is no provision of joint committee in the Act, on what basis this joint committee was formed, constituted?
We have provide two committee. One is district scrutiny committee, another
Other
is
state level.
state scrutiny committee.
Lordship may fix it on Wednesday, my lord, and I will take instruction Monday. If Lordship not satisfied, then Lordship may fix it on Friday for the secretary, my lord. So,
Heard Mr. M. Khan, Learned Counsel for the petitioner, and Mr. B. Talukdar for the respondent number 1, 3, 4, 5, and 8. Mr. Soliha, are you here? And Mr. Soliha for Finance Department. On the pair being made by Mr. Talukdar, Learned Standing Counsel for the respondent number 1, 3, 4, and 5, and 8. SSL lays the matter day after tomorrow so as to enable him to obtain necessary instruction in this court.
Number 49 matters for orders.
Is a contempt petition. It was filed in the year 2016. This is for non-payment of arrear pension for 14 months. Now, the order of this honorable court was passed in 2015. I filed the contempt in the year 2016. For the last 8 years, there is nothing going on. One of their affidavit, it was filed on 6/11/2023. Wherein in page number 6 of that affidavit, they have stated that there is a communication being made by Commissioner to the Director of Elementary Education dated 7th of February 2020 to process my arrear pension.
So there is an order dated 18/10/2023. On
Yes.
that day, the Learned Council for the Department of School Education submits that the order has been complied with as per
No, no,
instruction.
that the communication is also part of the record, madam. That is put on record.
Hmm.
Lordship may kindly peruse. That order speaks about an PPO of 2013. Pension payment order of 2013. I admit that I am getting regular pension with effect from 1/7/2011. That is the PPO order. But regarding 14 months pension, that is the arrear pension of earlier period, with effect from what is the order of this honorable court, my lord? That the payment of arrear pension from with effect from 1/5/2010 to 36/2011, that 14 months, that is not being included. It is not being paid. And that is what this honorable court directed in the writ proceeding. Regular pension I am getting with effect from the subsequent date, 1/7/2011. Prior to that, 14 months period, there was a gap there. They didn't pay. Therefore, we approached the honorable court. And therefore, this order was passed.
Order dated?
2/9/2015 was passed in the writ proceeding, my lord. Page 8 of my contempt petition. Page 10, paragraph 3 is the relevant portion, operative portion.
Yeah, that's all right, but who is for respondents?
On earlier occasion, Mr. Sisti appeared.
Kove? Department of School Education.
Here the party is Mr. Pritam Shoikia.
Hmm.
He is no longer the commissioner and secretary, madam. He retired way back on 2021.
And the second contempt now? Bhobesh Dekka?
Director of pension.
No, madam, I am not aware of.
Pension.
Director of pension.
Director of the government. No, madam.
So, is it necessary to implement the present incumbent?
Yes, madam.
Before that, I had to serve copies of this order to the present incumbent. I may be allowed some time to.
Heard Mr. A. Bhattacharya, Learned Counsel for the petitioner, and Mr. Khatonia for School Education Department. Mr. Bhattacharya press for granting him 2 weeks time.
Right.
So as to take necessary step to implement the new incumbents. Here is allowed list the matter after 2 weeks.
Much obliged.
At number 50.
My lordship, I am appearing on the behalf of Advocate and Islam. My lordship, step has already been taken on 29 September 2023.
It is an order to comply.
Khatonia, you are appearing?
Yes, madam. Order has been complied with, madam.
Complied with.
Yes, madam.
So furnish a copy to her.
Yes, well, I have already given a copy to her.
Wow.
Okay. Heard miss, your good name?
My lord, Soni Kumari
Learned counsel appearing on behalf of Mr.
and Islam.
and Islam Learned Counsel for the contender. No, for the petitioner and Mr. Khatonia, Learned Standing Counsel for the contender. Mr. Khatonia has produced an order of
5/10/2023, madam.
the Director of Secondary Education dated 5/10/2023 and submits that the order of this court has already been complied with. Let a copy of the order placed before the court be furnished to the learned counsel for the petitioner, so as to obtain necessary instruction in this regard and list the matter on
16 December.
16 December.
51.
Please, your lordship. One of the matter relates to the refund of excess royal, my lord. And already, my lord, finance department has given, my lord, approval in the month of August, my lord. But still money is not, my lord, released, my lord, to me. I will retired teacher, my lord, suffering from illness, my lord, waiting for this money. I did some treatment, my lord.
So it is pending with the finance department.
Yes, madam. The problem is here, madam, amount has been sanctioned. It is accorded by the department also, my lord. But when it is placed before the treasury, my lord, there is no specific head for refund of that amount, my lord. So treasury returned it, my lord. Thereafter, we submitted proposal to the finance department for creation of a specific head to refund the amount, my lord. So it is placed before the finance on 23/10/2024. Very recently, it has been placed before the finance. Once the account head is open, my lord, we can refund the amount, my lord.
Okay, regarding this, lordship, I have not received the communication. Lordship, may give me 1 week's time, lordship. I'll get an update, lordship. We were not aware because our last instruction on August, we had given our concurrence. And this is a subsequent development. So lordship may just grant me 1 week's time. I'll get an instruction on this because if it's been sent on
23rd of October.
I'll get an
Okay.
update, lordship. 1 week's time.
Heard Mr. A.F.N.U. Mullah, Learned Counsel for the petitioner, and Mr. Khatonia, Learned Counsel for the contender number 1 and 2, and Mr. Soliha, Learned Counsel for the respondent number 4. Respondent number 4. Mr. Khatonia has produced a letter of the Undersecretary to the Gautam Assam, Department of School Education, addressed to the Senior Standing Council. And submits that concurrence of the finance department has already been received, and the department has requested the finance within bracket budget department for creation of the new head of account, which is still awaited on 23rd/10/2024, which is still awaited. At this stage, Mr. Solia submits that he may be granted 1 week time to obtain necessary instruction, up-to-date instruction. Prayer allowed, list the matter on
2nd December.
2nd December.
Large sums, my lord. Large sums may be given. Because, my lord, this is not the only case, my lord. Earlier, so many orders were there, my lord, regarding access royal. Access royal has been refunded, my lord. So how those orders were carried out, my lord? This is a new concept, my lord.
Lordship will see if we are
No,
willfully
it may take some time to create a new head of account. So that
Earlier-
formality has to be observed by the
My humble
department.
submission, my lord, earlier there was no such requirement, because this is not the only case, my lord. So many cases were disposed of and money refunded, my lord. Then this, my lord, a head was not, my lord, required to be created. That I submit.
When there is deficiency in funds, Lordship, this is something that has been done because maybe there is a deficiency of fund, because of which a new head needs to be required, Lordship. That creation, it's taking time because there is some shortage of funds. So this is a necessary step, Lordship. So we are trying to comply with the order, court's order, only some time is required. These are mere technicalities, Lordship.
So
In
wait for
other
next
case-
date.
In other cases, my lord, interest issue aspect is there, but in this case, there is no interest. Had there been interest, my lord, the matter would have been done promptly.
Lordship will see if there is any willful.
There is no interest, my
We
lord.
are
Okay, wait for 1 week.
Yes.
Let them obtain instruction.
Obliged, my lord.
Item-
Date, my lord, may I pray for a date, my lord?
This is the.
Second
Yes,
December.
we have already. given.
Obliged, my lord.
Item 52.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. M. Soitya. Lordship, as per Lawazama report, by its order dated 13/11/2024, the step was taken, the respondent number 7, who is a private respondent. And so, push the matter to the next stage for admission, Lordship.
Heard, Mr.
J. Firdaus.
J.
J. Firdaus.
Learned counsel for the learned counsel appearing on behalf of Mr. M. Soikia, learned counsel for the petitioner.
Date may be fixed.
Mr. Soikia submits that service upon respondent number 7 has already been completed and the matter may be fixed for admission on next day. Pair allowed, list the matter on. Sorry.
On 18th December. Item 53.
This is regarding, my lord, provincialization of service, my lord. Currently, the petitioner
Hearing,
and
my lord,
the-
we have issued a notice to the petitioner for hearing to be held on 22/11/2024. So my lord may fix it after 22/11, my lord. They've already sent a notice to the petitioner.
22/11.
Yes, my lord.
Hearing was, my lord, already taken, my lord, conducted. As
I'm-
per the last order,
My lord, kindly
see the last order, my lord. Different submission was made on last occasion, my lord.
I'm submitting on behalf, on the basis of an instruction, my lord.
So next that is fixed on 22/11. Wait for some time. Heard Mr. Mullah, learned counsel for the petitioner and Mr. Khatonier for contender. Mr. Khatonier has produced a letter dated 16/11/2024 written by Deputy Secretary to the Goktav Assam Department of School Education.
আছে আপোনাৰ petitioner এতিয়া proof আছে আপোনাৰ আপুনি
To the Director of Elementary Education and also to the District Elementary Education Officer Goalpara and the petitioners fixing 22/11/2024 for hearing. And accordingly, Mr. Khatonier prays for listing the matter after 22/11/2024. There is accordingly allowed recessal list the matter on 29.
Yes, my lord.
29. 29/11.
54.
Problem.
Mate. In this case, one AD cast has returned, my lord, as per office note 2510, my lord.
wait, it's like X. Itu nih, like to equal limit like
Illegible signature. With seal signature. Department of seals. Department of.
Heard Mr. R. Islam, learned counsel for the petitioner. Office note dated 25/10/2024 indicates that Eddie Kurt in respect of issuance of notice to the sole respondent return with seal and signature of the office of the respondent, but none entered appearance for the respondent today. Mr. Khatuniar, yes, Director Elementary Education.
Lordship.
You.
Lordship.
So notice was served, but who will represent the respondent?
Lordship, here perhaps. Lordship will fix after 1 week. Sorry, my call is. Okay.
Mr. Sharma, learned counsel for the education department, elementary education department. Press for 1 week time so as to obtain necessary instructions. Here is allowed. Place the matter after 1 week.
Yes.
55.
May I please, your lordship? Lordship, the matter relates to insurance, no, principal, your lordship. And lordship, steps has been taken on 13/5. On lordship 16/5/24. And lordship now, today's November, lordship, till now, lordship, affidavit has been not been filed. And lordship, the seniority list, your lordship, is on page number 26, your lordship. And your lordship, Laosima Court have passed an order, your lordship, on 13/11/24.
Along with NLS.
So you have been directed to take fresh step upon respondent number 4.
4 and 5, your lordship. Lordship, in spite of order 5/9 CPC deemed to service of 30 days, your lordship. In spite of this, that order has been passed by law.
Service report always the different. That's just the one notice. Get it PDF version,
So as per this order dated 13/11/2024 of Laosima Court, you take fresh step. Heard, Mr. Your good name, please.
P. Chakraborty.
P. Chakraborty, learned counsel for the petitioner, and Ms.
I'm appearing for 1, 2, and 3.
What's your date?
Secondary education.
P. does learned counsel for the respondent number 1, 2, and 3. Office note, order of the Laosima Court dated 13/11/2024 indicates that the petitioner was directed to take fresh step upon respondent number 4 by registered post with AD and also by usual process. But no step has been taken pursuant to order dated 13/11/2024. Accordingly, it is provided that the learned counsel for the petitioner shall take step upon the respondent number 4 pursuant to order dated 13/11/2024 of the laws in my court.
But in the meantime, they can file an affidavit. If they want.
Okay, in the meantime, the counsel for the respondent number 1, 2, and 3 shall file their affidavit.
What is the date?
Deeply obliged.
After 4 weeks, so we have only issued notice.
What if the matter can be infructuous, Your Lordship, by any lordship?
But anyway, the respondent number 4, can we dispose of the matter?
Item 57.
As per order of the laws on code, there is 14/11/24. The notice upon private respondent 4 and 6 are deemed to be served. So therefore, Lordship, the service upon all the respondents are
Completed.
So matter can be fixed for admission.
Okay. Third, Mr.
I have
I, Hussein.
Hassan.
Hassan, learned counsel for the petitioner. And Mr.
Lordship, I am appearing for respondent number 4, Lordship. M. Ahmed.
M. Ahmed, learned counsel for the respondent number 4, and Mr. Bhuya for respondent number.
1 and 2, Lordship.
Respondent number
1 and 2.
1 and 2, and Mr.
R. Bhuya, Lordship, for respondent number 3.
R. Bhuya for respondent number 3. Respondent number 5. Your name? The learned counsel for the petitioner submits that service upon all the respondents completed and the matter may be listed for admission hearing. Pair is accordingly allowed. Recess will list the matter for admission hearing on
18 December.
Lordship, can it be before 18?
before 18.
First week of December.
13 December.
Correct. First
On 13 December.
week of December, Lordship.
First
Any-
week,
any-
first
anything-
week, first week not possible. A video. Maybe.
On 6 December.
6th of December.
Obliged.
Item number 62.
Make resolution. My Lord, there is a delay of 13 days in filing this review application. My learned friend, they have filed one objection saying that there is a delay of 43 days. This is not correct. They did not, my Lord, minus the statutory period of 30 days. If we deduct that 30 days, then it is 13 days only. So therefore, my respectful submission is that delay of 13 days, Your Lordship may be kind enough to condone that and fix it
Yes.
for admission.
My lord, today morning we have filed our objection, my lord. Perhaps, my lord, the objection is not in record, my lord.
Morning.
Then day after tomorrow, Your
Day
Lordship.
after tomorrow, okay. Okay. Heard Mr. S. Dotto, learned senior counsel assisted by Mr. Biswas. A. Biswas, learned counsel for the applicant, and Mr.
HP Gwala, my lord.
SP
Gwala.
Goala, learned counsel for the respondent. Mr. Goala submits that he has filed affidavit, the objection petition today,
My lord.
and the same is not placed on record. Accordingly, it is provided that recess will list the matter day after tomorrow, enclosing the objection petition.
63 and 64.
Obliged.
My lord, this IA has been filed by the applicant saying for some interim protection, my lord. The fact is that I have challenged the order of the private respondent whereby he has been allowed to hold the charge of headmaster of ME school, my lord. And this honorable court was pleased to direct the standing council to obtain instruction
matter has been fixed on 22nd of November. The ground of challenge of that appointment order was that date of joining of petitioner and the private trustman are same. If date of joining are same, then date of birth has to be taken into account. My date of birth is 24/1/1968. And private testament date of birth is 27/11/72. So I am senior in respect of age. And therefore, the Honorable Court directed the standing council to clarify the position, who is senior among us. If I am senior, then I should be allowed to hold the charge of headmaster of the school. But when the matter is examining by this Honorable Court, the notice was issued on 4th of November, directed the standing council to obtain instruction. But on 11/11, page 15, I have been thrown away, transferred to another school. When the matter is in session, this Honorable Court is examining my seniority issue, I have been transferred to another school and directed me to join immediately. So I approach this Honorable Court by filing this IA. Till that, my lord, I may be interim protection, my lord. Status quo may be granted. I have not yet joined in the transferred school. The main matter is fixed on 22nd. 22.
Yes, madam, you are for?
Lordship, I'm appearing for respondent number 5, Lordship, that is Zahiran Amin.
Respondent number 5.
Lordship. In this IA, Lordship, the
And
petition-
Mr. Talukdar, you are?
Order elementary division. Elementary division.
You are for?
1 to 4.
1 to 4, my lord.
1 to 4.
Lordship, in this case, in the main case, we have filed our objection, but that has not yet been tagged yet. We have filed it on Thursday. So as the matter is fixed on 22nd/11, so we will like to file an objection in the IA.
Let them file, my lord, but till then, my lord, I may be protected. Otherwise, department may take any action because only to favor the private testament.
You have been transferred.
Yes, I have been transferred to another school.
The petitioner is already given a transfer order and is also provided with the release order from the earlier school, Lordship. But he
My
has not-
colleague cannot release
Why?
me, my lord. Who
But
is
he
senior
is the
to me.
temporarily in charge headmaster of the school. And in this transfer order, he is also appointed the temporarily headmaster of the Udar Bhui ME school,
Another school.
another school, temporarily, but of the another school.
Page 11 is the silence, which is under silence. Page 11. This honorable court is.
But why he was transferred while the matter was pending before
There
this
is no
court?
necessity, my lord. They can wait for 1 week or 2 weeks. What was the
This
necessity?
order was by the district elementary education officer.
Mm.
So being the in charge headmaster of the school, he has just given a release order from the earlier school. That is the thing.
No, he could have waited till disposal of the petition
Yes.
before this court. Heard, Mr.
Answer, answer,
N. Sarma, learned counsel for the applicant. And Madam
A Bora.
A. Bora, learned counsel for the respondent number 5, and Mr. Talukdar for respondent number, no, for respondent opposite party number 1, 2, 3, and 4. This interlocutory application is referred by the applicant for staying from suspending the order under memo number DEEO stroke SSM stroke transfer dash posting stroke 2024 stroke 287 dated 11/11/2024. Education come IC District Elementary Education Officer, South Salmara. It is to be noted here that by order dated 11/11/2024, the applicant has been transferred to Udar Bhui ME School, while his claim for in charge headmaster in Zaudanga ME School is pending consideration before this court in WPC number 5620 of 2024. Mr. Sharma, learned counsel for the applicant, submits that the applicant has challenged
Page 11,
in rate petition.
petition page 45.
It's 45.
Challenge the order dated
22nd, 10, 2020.
22nd 10/2024 passed by the District Elementary Education Officer South Salmara Mankasar. White memo number DEEO/SSM/MS/ selection dress promotion/PT Roman 2 the stroke 2024/274, by which the respondent number 5 was temporarily allowed to act as in charge headmaster cum member secretary to draw and disburse the monthly salary of the teaching and non-teaching staff and other financial work of the school in addition to his normal duties until further order. Due to transfer of the present petitioner,
Not petition. Another teacher, Ibrahim Ali Khandakar.
no, due to transfer of, not present petitioner, due to transfer of
One Ibrahim Ali Khandakar, headmaster.
due to transfer of one Ibrahim Ali.
Yes.
Ibrahim Ali Khandakar, headmaster of the said school. And in the said rate petition, notice was issued.
Not notice. Notice was not issued, only direction was issued to obtain instructions regarding seniority position.
In the said petition,
Page 14.
by order dated 4/11/2024, the Standing Council for the Elementary Education Department was directed to obtain necessary instruction. And while the court is insisting of the matter, the District Elementary Education Officer has issued the order dated 11/11/2024, whereby the petitioner, whereby the applicant was transferred to Urar Bhui ME School. ME School. And that the writ petition number 56/2020, no 5620 of 2024 is fixed on 22/11/2024. 2024, and till then, Mr. Sharma contended to stay the order dated 11/11/2024. Having heard the submission of Mr. Sharma, learned counsel for the petitioner, and Madam Bora, learned counsel for the respondent number 5, and Mr. Talukdar, learned standing counsel for the respondent number 1, 2, 3, and 4. And also having found a prima facie case made out for staying the impugn order dated 11/11/2024, this court is inclined to allow this interlocutory application by staying the impugn order dated since till 22/11/2024. Ms. Bora learned counsel for the respondent number 5 submits opposite party, respondent opposite party number 5 submits that she may be granted time to file objection to this interlocutory application. Where is accordingly allowed. Please the matter on 22.
27.
Much obliged.